It was arising out of the order passed by your lordship on 7th February 2024. And Lord, the review was filed, my lord, long back, my lord. If this can be included in the list.
Yes, give it.
Or for the inclusion in the list, your lordship.
Give the inclusions. All inclusions. One. Another. First time. Yes. Oh, file is not. To call it, we just have to pronounce it. কালকে হিয়ারিং আজকে করিস না দেরি নেই
The appeal shall be heard on the following substantial question of law: whether the suit disposed by the trial court is barred by the provisions of Order 2, Rule 2 of the Code of Civil Procedure.
With all humility, may I submit only one thing? On the last occasion, Lord, you kindly appreciate my predicament. My lord, on last act me
if another point be subject to correction be added as law point subject to correction. Now, my lord, Order 2, Rule 2 is the one of the ground for admission of the appeal. My lord, if my lord consider Section 34 proviso, because the relief which has been sought for in earlier suit, if he not paid for, in second suit, my lord, there is a debarred that has been held by the Honorable Apex Court, also subject to correction if your lordship consider.
If the bench feels it to be added, then it can always be added at the time of hearing.
On a last occasion, my lord, I have paid for your leave of right of audience, citing one judgment. Kindly, my lord, appreciate my predicament, lordship, that we are the creature of instruction. So that if it is just recorded that I have paid for an right of audience and that has been declined, your lordship can always.
All right.
Kindly record that submission that I have relied upon a judgment of the Honorable Supreme
All right,
Court.
we have got it. You have got your judgment. You have already given us.
So lordship, kindly add one line, madam.
Now, my lord, there is an application for stay.
That has to be heard with a single way.
No, not that by division bench, my lord. Kindly see there is judgment. Your lordship kindly remember, my lord.
The appellate side rules is very clear.
Absolutely, my lord. If he says this,
My lord, if your lordship wants to hear this, I will not stand in the way, my lord.
he is practicing since long. He knows this procedure of this court.
If your lordship,
The judgment of all the division bench subject to correction by your lordship. If, my lord, the execution case court is passing the interim order with sudden rider condition, whatever may be the court thinks, but my lord, after admission and the grant stay, court can relegate the matter before the final hearing be done by the Honorable Single Judge. But the grant of interim order that has already been decided by this Honorable Court.
and your lordship, if your lordship wants to take out the stay application, my lord, here's the stay application, I can take it up tomorrow because my lord, matter has been upgraded, my lord, without any notice. I am completely. I didn't know that the matter will come at 10:30 today, my lord. I'm surprised. I have found that matter has been upgraded to 10:30 matters. Lordship, kindly take it up on tomorrow.
In the if your lordship sees this judgment, but that has been considered whether paragraph 6. My lord, from paragraph 3. This is an application for stay of execution proceedings filed at the and I have the judgment also with Justice Tandon and Justice Prashad, my lord, also. But I would not cite that that has also been.
তুমি যা বুঝিয়ে গেছো 41 এ
section what of it to write about it. There are
I don't have, my lord, I don't have any problem in arguing before you.
Understood what you are saying.
Chapter 2 is very clear, my lord. The connected application is to be heard, my lord.
Chapter 2 has already been decided by this Honorable Court.
Right.
Will be heard by the single bench.
But kindly visualize. But today, suppose your lordship admit the appeal. But that tomorrow they will say there is no order of stay. Now, my lord, kindly visualize. This has been decided by this honorable court that, my lord, after admission, your lordship has the power to grant stay or refuse stay. Now, my, it is not that, my lord, that the after admission this cannot be. But there are several judgments. If your lordship want, I can cite, my lord.
The appeal of
Please wait.
2023.
But this is too much.
Appeal
But
of
every time we are practicing more than 26 years, we used to move the order 41 after order 41 stay is granted by the division bench. This is not the first case, but what he is saying is absolutely wrong. With
My lord,
respect to him.
if your lordship takes up the matter, I don't have any problem. My lord, in lordship, kindly take up this matter tomorrow, my lord, because today I'm not.
Judgment. He appeared. The stay is granted. Let him deny that. But this is the
Well,
normal
that-
procedure of
well,
this
when,
honorable court.
along with the order 41 rule application, my lord, when the application.
See what is order 41 rule 11? Kindly see one civil procedure code. The hearing be done initially, order 41 and appeal be heard by the honorable division bench. Subsequently, there is the amendment in the appellate side rules. In that amendment, final hearing has to be done by the honorable single judge. That has been amendment of the appellate side rules. Now-
He is not objecting that we cannot. He is saying if we want to hear, then he should.
Kindly protect me for my 7 days or 10 days. Tomorrow is the date for it. But if they took the position, my court has
Can you take it on tomorrow, my lord?
So if we have to, if you want us to hear the stay, then he will have a right to address.
Let him hear. But when the application is admitted, now my lord, I am entitled for a stay. Whatever, because my lord, I can't obtain a blanket stay. It is a after and other judgment that I am not on that because I have to. I know the procedure. Now the question is that if today your lordship relegate the matter to the honorable
When is the date fixed there?
tomorrow, my last time Friday was the date fixed. My
The
your
appeal of
please,
2023.
Please allow him. Why? Is there any point in speaking side by side?
What was the date
Well,
fixed
no, no.
for?
delivery of position, my lord, execution is pending from long time. Let him say till 10 days he will not do anything. Kindly protect me for 10 days. Because my your lordship knows, your lordship signed the order that will go to. Kindly grant me for 10 days. Definitely I will go before the honorable single judge. That has been considered, my lord. Kindly see.
The appeal
Madam,
of
may I just complete
2023,
your lord?
my
May I just see? My lord, what happened? Your lordship knows, my lord. My Justice Bhattacharya, my lord, kindly.
Let the
lord.
let the matter be fixed for tomorrow.
If your lordship desires to hear out the say application, my lord, the thing is this, my lord, the appeal is pending since 2023. The matter was extensively heard by your lordships in the last year. Thereafter, my lord, he didn't take any step to, my lord.
That's why he will take the
my lord,
position.
no, my lord. The execution case was pending when he enjoyed the possession, my lord, without mentioning the matter for admission hearing.
My
My lord,
madam,
the moment the execution case has been matured, he rushed to the court, my lord. For last 1.5 years, he enjoyed, and last 3 occasions, my lord, I instructed an advocate in the trial court, my counterpart, that not to take any step. I have shown my enough bona fide. But 2 years, my lord, he has not taken any step.
What he is saying, I can understand.
The execution case is
Everything.
pending. Execution is pending since 2023.
Further, then he will take position.
There is an application.
Absolutely, my lord.
Which application?
Before your lordship's court, my lord.
Kindly, I'm coming back. Can one.
And one. But although I don't want to cite, but there is a reported judgment passed by Justice Chandan sitting with Justice Prashad limited because I can't often stay order blanketly. I have to pay the occupational charges because that is the judgment of the apex court. That my lord, if it is eviction decree. Eviction decree, my lord, rightly wrongly, both the courts, my lord, was against me. If I want to enjoy the property, I have to pay the occupational charges, and that is a condition precedent. But kindly see the stay application, my lord. If your lordship see my prior stay, my lord, at page 5.
But that day you could have pressed this when you were arguing. That's why we didn't allow him to argue.
But on,
He said it was only on the point of admission.
after
He was trying to make his submissions.
don't take me otherwise. After admission, I can press for stay. Before admission, I can't move. I can utter a word before the
That we know, but you could have said that you will be proceeding.
No, that if your lordship don't take me otherwise, kindly remember when on the first day I said, kindly protect me for some time. Your lordship, with discussion with the honorable Justice
Yes, yes.
Bhattacharya said, unless it is admitted, we can't grant any
We
stay.
thought you were, because we were admitting it,
Your lordship
we are
knows
considering it on the point of admission. No,
Normal-
that we understand.
Normally, what we are doing, don't take me otherwise. After admission, we used to say that we don't know whether appeal will be admitted or not. That
Correct.
we are pressing the applicant for stay. It is a normal procedure. He knows it.
Yes.
But in
No,
that
that's why
event,
no-
my lord, in that event, I'm coming back tomorrow. Let him.
Tomorrow, my lord, the date is, my lord,
Tomorrow at 10:30, my lord. And tomorrow on 10:30, my lord, on last 2 years, the execution case has not been proceeded. I think tomorrow the execution case will not be proceeded, my lord, during the due. So when the appeal has been admitted, usually the trial court do not proceed.
normally not that, because court has said if letter has been
But
given,
last 2 years, the same thing is
But
going
for
on. My lord.
that-
It took time in the execution process. One day, my lord, is. My lord, I will convey. I will again convey, my lord. I will again convey.
my lord,
But last 2 occasions I conveyed and that worked.
that will not, may I? What will happen if I say?
Hello.
But after admission, I'm entitled under the law for some protection. What he is entitled.
He just wants an audience. He doesn't want anything but.
Today I'm not ready. The matter has been uploaded at 10:30 matter without giving any notice to me. In certain surprise, tomorrow I have found that the matter is appearing. Matter.
Matter has been upgraded.
Today in the 10:30, yesterday the matter was appearing serially.
Yes.
So I was under the impression matter will be taken up serially. But he my lord, correctly he has my lord mentioned this matter because he has some urgency. I don't
But
deny
it
that.
was not mentioned today.
Yesterday the
mentioned
matter was mentioned.
yesterday, yes.
Yesterday the matter was mentioned. But I was not communicated, matter that I didn't know the matter will appear today at 10:30. So I'm ready with the. I'm not ready with
But
the
you have
statement.
been appearing in the matter.
Yesterday, the matter was mentioned yesterday.
night,
Yesterday, the matter was appearing serially in the list.
Yes.
And the instruction in the list, the matter will be taken up serially.
Yes.
So I was under the impression matter will be taken up serially. But yesterday he mentioned, he rightly mentioned, because he was under urgency because the my execution case was proceeded with the matter. So my lord, the matter has suddenly came at 10:30. So I'm not ready with the stay matter. My lord, let me. I want to cite some judgment. I found it out.
Come in the second half. Bring your judgments.
But
Come
can
at
I
2 p.m.
at
Now
10:30?
it is in your presence.
At 10:30.
Now it is in your presence.
10:30 tomorrow, my lord.
Come at 2 p.m., sir.
Can it be
Entire thing at 2 p.m.
at 10:30 tomorrow, my lord? I will convey, my lord. No
You are
steps will
raising
be
a
taken.
unique objection, therefore.
No, my lord, I'm
Come
not.
at 2 p.m.
I'm not objecting, my lord.
Now it is in your presence. Now we'll decide.
No, 10:30, my lord, tomorrow, my lord. My lord, I will convey, my lord. No steps will be taken, my
No, not.
lord.
Come at 2 p.m.
Well, my lord, don't take me amiss, my lord.
We have understood. You come. We
Well, I am
understand
not.
what you are saying.
Why I am not prepared? I have just tried to
You are
say, my lord.
appearing on every day. You are watching the proceedings, and today you are saying as if we have upgraded it behind your back.
No,
What
lordship,
kind
that
of
is not the
submission
issue,
you are
my lord.
saying?
Your lordship didn't do it. I am not.
You are asking us to record submissions of your appearance. At the same time, you are saying I don't know
My lord,
anything.
yesterday the matter has been as
Okay,
was
so
mentioned.
come at 2
My lord,
p.m.
kindly take it 10:30. Don't take me amiss, my lord. If I said anything wrong, my lord, I'm apologize for that.
Sorry.
I'm undertaking apology. My lord, kindly take it.
We
tomorrow.
understood what you were trying to
Man,
say.
no, my
You
lord.
said you wanted us to record submissions. You said you are a creature of instruction. All that we understood. Now, all of a sudden, you are saying as if you don't know anything.
My lord, I didn't.
You have argued the matter.
My
You have
lord,
tried to argue the
my lord, I
matter. You
knew
have
everything,
cited
my lord.
judgments.
My lord, don't take
And
me.
now you are saying that we have upgraded it. We
No,
have
no, my lord.
So now it is in your presence.
No.
Come at 2 p.m.
Lordship, kindly don't take me amiss, my lord. Can't 10:30 tomorrow. My lord, if I submit anything wrong, my lord.
You are appearing in court every
No.
day. This is the way.
No, Lordship, I'm
You have not appeared.
undertaking my apology. Lordship, kindly appreciate the thing.
No question of apology, sir. We
Yes,
have
Lordship,
understood
I
what
did.
you want.
Suddenly in the.
You want an audience, you have got an audience. Now it is fixed in your presence. at
Lordship,
2
kindly
p.m.
10:30 tomorrow.
Sorry. Now he is gone. Now in behind his back, we'll not do anything.
Well, I will.
Come at 2 p.m. We'll see.
All right.
One.
This matter, regarding here found judgment was referred by placed to the judgment of Pawan Kumar Singh, Pawan Singh, Avtar Singh also considered that in case of petty case and a tribal in nature, the same can be considered by the court, honorable court, Here, what happened, before they have taken into consideration my candidature, and whether I am suitable or not, I have informed and intimated the fact that the criminal case is pending. It is true, in my VR form, in respect of the criminal, whether any criminal case is pending or not, it was written as no. It is admitted fully. But they have not considered as a unsuitable to me, regarding that, on the basis of that VR form, According to them, since criminal case is pending, criminal case, though I have acquitted, I am not suitable, kind of, I have initially I have filed a original application before the learned tribunal in the year 2011, wherein I have stated that criminal case is pending. Considering the same, or judgment order was passed by the learned tribunal, kindly come to page 66 of my petition, it was held, that we dispose of the application with the observation that the petitioner's claim for appointment would arise if he is acquitted from the criminal case. Now, they have considered my candidature. Kindly come page 73, Statement in respect of the Narayan Patanda, such and such, elected for appointment. In the year 2017, they have considered my candidature that I am unsuitable, and the same was handed over to me, the state memo, report the honorable court, when I have filed a writ application challenging the same, regarding, so far as their form is concerned, they have stated the same in their rejoinder only, before the learned tribunal. So, due to mistake, bona fide mistake, it was written as.
Relying on you have given us this judgment, you are relying upon.
This Satish Chandra Yadav, 2023 7 SCC.
Yes. Oh, this is reported now.
23 volume 7 SCC.
536. Can you please repeat the citation?
2023.
Yes.
7 SCC, page 5. Date of judgment very important. 26 September 2022.
2022.
And the judgment of Pawan Kumar delivered on 2nd May 2020.
May.
2nd May 2020.
Pawan Kumar was discussed in the judgment of Satish Kumar Yadav.
So admitted position is that there is a non-disclosure. There is no dispute that there is a non-disclosure.
That's true, but no, that's true, my lord. Now, my lord, what happens is, in respect of the judgment placed by my learned friend Satish Kumar Chandra Jadhav, the judgment of Pawan Kumar also, my lord, discussed, and my lord, kindly consider the judgment of the Avtar Singh, my lord, which was judgment wherein, my lord, the guideline was recorded, my lord.
So where is the impugned order before the tribunal? Which order was impugned before the tribunal?
Tribunal impugned order, my lord. So page 73, my lord. Page 73. Just and my lord, page 74. Declaring unsuitable, my lord. My lord, statement, my lord, kindly consider, my lord.
So before appointment, they have.
My lord, before appointment, in their impugned order, there is no such observation that they have considered my PR form, and since the same was suppressed.
Page 74 is the impugned order.
Impugned order, my lord, that earlier one, 73 is also, my lord, their statement or consideration, considering me as unsuitable, my lord. In this case, my lord, nowhere it was stated that I have suppressed any facts regarding PVR in my PVR. Only before the learned tribunal, they have submitted, my lord, rejoinder. In the said rejoinder, they disclosed that I am unsuitable since I have suppressed the facts in my PVR form. And I have, against that, I have also filed my reply. My lord, thing is this, my lord, in the year 2011, my lord, I have submitted and stated before the authorities that a criminal case is pending, and I have also filed an original application to the tribunal and earlier occasion also.
No. This order of 12 July 16 at page 74. This is the impugned order before the tribunal.
No, sir.
So, what is your submission on this?
My lord, regarding this, my lord, this since they have in their filed the rejoinder in this before the tribunal, disclosing that in my PVR form I have suppressed the facts, but in their impugned order the same was not disclosed.
So this does not assign that reason.
Yes, my lord.
Where is that rejoinder?
Rejoinder, my lord, next page, my lord. Rejoinder, my lord, page 94, my lord. My reply.
Reply on behalf of the respondent, page 87, paragraph 3 of my reply.
No, rejoinder is at page 94.
Reply has, my lord,
Page 87.
reply page 87.
Paragraph 3 of the reply filed before the trial.
Paragraph. Only this is the first time they have disclosed that there is a suppression of my in my.
No. Initially, you have moved the tribunal,
Yes, my lord.
showing that criminal case is pending.
Yes, my lord. I have not suppressed.
As soon as the guilty
That is my case, my lord. I have not suppressed. And my lord, the learned tribunal disposed of the said application, declaring that, my lord, after acquittal, I will be, my lord, considered, my lord. My claim will be considered after my acquittal. After acquittal, I submitted representation to them. They have.
So this is an earlier proceeding.
Initially, I have in the year 2011, I have filed an application, original application with the tribunal. Kindly come to my page 66, the order of the learned tribunal
In the earlier proceeding.
earlier proceedings. Earlier proceedings was decided in their presence. No rejoinder reply was filed by them, and my lord, learned tribunal was pleased to, my lord, pass an order observing that my claim will be considered after my acquittal. Therefore, after acquittal, I intimated the
before the authorities that I was acquitted pursuant to the judgment and order passed by the appropriate forum. Thereafter, my lord, I have since they have not considered, I have filed further original application before the learned tribunal. Why challenging their impugned order, my lord. My lord, the impugned order was handed over to me, my lord, when I have filed a writ application before the honorable court that the police verification report is not, they are not considering my the police verification report. And before the records regarding my page 73 and 74 was submitted, handed over to me, my lord, and challenging the same pursuant to liberty granted by the Honorable High Court, my lord, I have filed further original application before the tribunal. And my lord, before the tribunal, they have filed the reply. When they have disclosed that my candidature is not considered, since I am unsuitable due to the suppression of facts. It is true, my lord, it was suppressed, but my lord, so far disclosure on my part prior to their decision was made by me before the authority in the year 2011. It is a mistake, my lord. It is not that I have not disclosed them, my lord. But my lord, this fact was not considered. And my lord, my case is, my lord, only 498A against me. The petty since it is, my lord, actually, my lord, the wife of my elder brother initiated proceedings against my elder brother. Since I am the one of the resident of the said premises, my name was also, my lord.
So when the acquittal was recorded?
My lord, acquittal was recorded, my lord, by making a petition before the authorities. My lord. That page, my lord, 71, my lord, 2014, my lord,
Page 71.
71, my lord. Application regarding necessary steps for completion of police verification report, such and such. With due respect, Narayan Patona, such and such, would like to draw your kind attention that I have selected for the post, such and such, but I cannot join duty to advance report on police verification reports I completed on the plea that I am implicated criminal case being such and such. Now, the aforesaid criminal case was finally adjudicated by the learned judicial magistrate, such and such, and I am being found not guilty. And so I requested the child. 2014, I have, my lord.
Then you made your application which has been rejected at page 74.
My lord, prior to that, I have also filed writ application before the Honorable High Court. My lord. Honorable High Court was pleased to send the same and liberty was granted to me to file original application before the learned tribunal. And I have filed that.
When that writ petition was filed? After this application?
Yes, my
After 2014?
lord. 2016, my lord.
Where is that? Let us see the order. Is it there?
Yes, my lord. So page 72, my lord. Page 72, thereafter further writ application, page 76, my lord. Initially, writ application was filed and they have submitted a report. This report is challenged, my lord, further before by filing a further writ application, page 76, my lord. Further writ application, when the Honorable Court was pleased to grant me liberty to file original application before this tribunal. 76 further order. Actually, my lord, this mistake was done, my lord, in VR form. NA was written, but as far as criminal case is pending, the same was recorded before the authorities prior to their considering me as unsuitable, my lord. And but, my lord, there is also, my lord, is my lord, well settled principle, my lord. If anything is not recorded in the impugned order, my lord, the same cannot be taken into consideration by way of, my lord, affidavit and affidavit in opposition before the
And what is the advertisement, date of advertisement pursuant to which you applied?
2008.
8.
Paragraph, my lord, page 73, my lord. Page 37, my lord, I read, my lord.
So the state has appeared in the earlier OA also.
Lordship,
OA 751, you have appeared.
Lordships. In their presence, the same was, my lord, considered.
So that order, you did not challenge that order.
No one, they have not challenged.
Then how you can raise an objection that after his acquittal, he will not be allowed to join?
On the question, suppression of PR form. If there is a suppression of that,
No, there is no suppression. You come to the order, page 65. Where is the question of suppression? You are a party to those proceedings. So whatever is recorded in that order, now you cannot question.
no, I'm not. July 2012.
Yes.
We find sort of law they do not require any formally reply from the state. Appreciate by the commission. That stated one particular task, not asked to submit the inspection form of petition before the actual appointment. School, school with the sound that we have given.
Yes.
Under section 490, Indians of the country, for the dictionary have therefore ignore the impact of pending case and issue upon the data. Since Agarwal on instruction submit that it is the on hearing Mr. Bhattacharya and Mr. Agarwal when the case issued involved in the answered by the of India. In case of state of without from the reported decision find that the decision question whether a person profession is selected within appointment in a communication still and their brothers answered in such as no order to be given upon the state government for issue of data so from and the incumbent has not been appointed of that single order the biggest state of the application with the operation of petitioner if he is applied from the previous application. That means that was not there.
Just see what the tribunal has said.
If he is applied from the previous,
And you are party to this decision, not challenge this decision. Now, how can you go back on this?
no.
Where is the question of now looking into anything? It was known to you before the tribunal that he is accused in a case. He said, allow me to join. That you, upon instruction, told the tribunal that only if he is acquitted, he can be permitted to join. The tribunal has said only if he is acquitted, he will join. So how can you raise an objection?
I will see that case is a potential one. And when a routine order are passed on 12th of July 2016.
Correct. How can you do it?
Yeah, whether I have got power on it. Yes.
No, it's not a question of power. It's a question of a decision binding inter parties.
Yeah.
The decision is binding both the parties and you have not assailed this decision. So now where is the question? Once he is acquitted, you have agreed before the tribunal.
As soon as he is appointed, he cannot give appointment on the basis of the, assuming for a moment that acquittal has been granted, we give the facts in detail.
No, that's not in dispute that he has been acquitted.
No, nobody is disputing. Now, but even after acquitted, state government can be compelled to issue an appointment letter to a person.
That's not the point. The point is, can you raise an objection regarding the criminal case when this judgment binds you? That's the only issue.
Only. But
How you are now can you raise an objection? You are party to the proceeding. Upon instruction, you have made submission before the tribunal. The tribunal has said after his acquittal, he will be appointed.
no.
Now you say that no, we will not do it because there is a suppression made by him. How can you cannot say it? You have agreed.
When this order was passed by the London Tribunal in 2012, obstruction was not there.
That's immaterial. The law remains the same. Suppression is a suppression. Avtar Singh does not.
If there is no suppression, even he has been acquitted, then what his past conduct can be.
No, that's we are not looking at hypothetical situation. The hard fact is that he is accused in a case of 2002. That accusation is in a 498A proceeding initiated against his brother by his brother's wife. Now that fact was he was faced with this fact when he was filling up the verification form. He came to the tribunal that look, this case is of such and such nature, ask them to allow me to join. You said no, we will allow only if he is acquitted. Now see, kindly see what Mr. Agarwal has said. Come to page 66.
Deed is acquitted in the previous cannot be considered. That does not mean
That we have seen what it means. That we have seen what it means. Because relying on this, the tribunal said that once he is acquitted, he will be considered. You did not challenge this order. Now you can't say this does not mean this and this does not mean that. What is the last portion of the order? Following the said decision, we dispose of this application with observation that petitioner's claim for observation would arise if he is acquitted from the criminal case. So his claim is arising. Now you cannot raise an issue regarding the criminal case. If he is otherwise unsuitable, we don't know. That we are not going to say. The issue is whether the criminal case can now be made a ground to deprive him of the recruitment. That cannot be. This is settled by this order.
and even his judgment, Pawan Kumar, but delivered on 2nd May 2020.
How that is relevant? We are
But judgment is not applicable in the facts of.
we are not. This judgment is binding you, sir.
Yes,
This judgment of the tribunal is binding you.
yes, but why, if the acquittal is made, acquittal has been made, even after acquittal, whether government can be rejected to appoint him in a post,
That is a different thing. There is one ground is that whether there is a suppression. Here he has been not appointed because you say he has suppressed. He has not suppressed. This judgment of the tribunal is there. Please see what it says.
page,
Impugn order says nothing. In your rejoinder, in your reply for the first time, you have said what you are doing.
page 74, page 74, July 2016.
Impugn order does not say anything.
Thank you.
No reason has been assigned.
Number sign is direct to refer to.
Only unsuitable.
Page 74.
Yes, you read.
Dated 2016 and memo dated 3rd June 2016 of the government subject to state that the government considers in the particular unsuitable for employment to the post of the under the department supply.
Nothing. No reason whatsoever. No reason whatsoever. Unsuitable.
Unsuitable. Unsuitable.
Whatever you say, that has to prevail. Unsuitable means unsuitable. Why unsuitable? You don't say. Now you supply the reason in your reply.
Yeah, that's-
Come to your reply. In the verification role, it is not mentioned involvement in criminal case.
I will calculate any.
So this ground now, whether the only issue is that whether this ground now you can take in view of the earlier order passed in the tribunal. That's the only issue. Other things, whether his even after his acquittal, he cannot be appointed, that you have not said. That's not there. There's not a reason assigned by you.
Cannot be justify my order of the basis of the reply issue. Or Delegate Supreme Court again clarified in 2010.
Hmm?
The order to sustain it. Affidavit, and we are filing affidavit, justify it.
That is what we are reading at page 87. Page 87 is your justification.
That's at page 88.
No, page 87 is the reason in paragraph 3.
Finding of the problem. In the rejoinder to the reply filed by the applicant, he ascribed such application of fact due to mistake and or incorrect. So that the objection of the document was appointed for the business case and the applicant would not have to be capacity for his proper appointment. But I not what is it? Satisfied. Part of the with the information that was on the application of fact is wrong. From resident.
That is nothing, but this issue is already how the tribunal can reconsider the same issue. Tribunal cannot.
But can you see
In the before the tribunal in these proceedings in OA 911 of 2017, did you disclose the earlier?
Yes, yes,
That
my
is,
lord. I
that
have annexed the entire original application before your lordship. This is the original application decided by the learned tribunal.
we are asking you again.
Lordship.
In OA 911, did you disclose the earlier order passed by the tribunal? Where is that? Show us. In your OA.
Lordship. My lord, page 66. This is the annexure in OA, my lord.
In OA 911.
Averment is also made, my lord.
page 304.
304.
Column number 13.
Yes, my lord. I order of proceeding. My lord, 18 September 2002, applicant was arrested and on 19th my lord, and on 19 September 2002, the applicant was released on bail. Next thing. Actually, petty case, my lord, he is not involved in the criminal proceedings.
We are not
Criminal
interested
case.
about that.
Lordships. Well, even my lord, in after-seeing as well. Lordships.
Uh, 2023, column 7, SCT, page 536, Suresh Chandra Jadhav versus Union of India. Paragraph 25.7. Yeah. But after she also considered it paragraph 7. Then my kindly see the analysis. Kindly see paragraph 93. All judgments, kindly see about 49 judgments have been considered.
But here, my lord, page.
Just give me 1 second. Just the total number of 47 judgments have been considered, including observation. Then kindly see that. In such circumstances, we undertook some exercise to shortlist the broad principles of law which should be made applicable to the litigants of the present nature. The principles are as follows. Paragraph 93. 93.1. Each case should be scrutinized thoroughly by the public employer concerned through its designated officers, more so in the case of recruitment of police force who are under duty to maintain order, tackle lawlessness, since the liability to expert perpetrator report Society Secretary Rajkumar. Even in case of employees get declaration truthfully and correctly a concluded criminal case, the employer still have the right to consider the antecedents and cannot be compelled to appoint to the candidate. The acquittal in a criminal case would not automatically entitle the candidate for appointment to the post. It would still be open to the employer to consider the antecedents and examine whether candidates are concerned is suitable and fit for appointment. The suppression of material information making a false information in the verification form relating to the arrest, prosecution, conviction, etc., has a clear bearing on the character, conduct, and antecedent of the employee. If it is found that the employee has suppressed or give false information in regard to the matter having a bearing on the fitness or suitability of the post, then he can be terminated from service. The generalization about use such as that, then one scope appeal 136. And after seeing, I think you are talking about after seeing. No. May I hand over after seeing? Your Lord's got after seeing. 2016, column 8, SSC 471. Paragraph 34. Thirty-four, 35. 38.4. 38.3. Employer shall take into consideration the government orders, instructions, rules applicable at the time of taking decision. In case there is a suppression or false information or involvement in a criminal case where conviction or acquittal already been recorded before filing the application, verification from such fact that have come to the knowledge of the employer, any of the following recourses appropriate case be adopted. In case tribal in nature which conviction has been recorded, such as a Southeast Global the report would not have been rendered unfit for the post, the employer being discretion ignore suppression of act on in the lab. Where conviction has been recorded, if acquittal has occurred, 38.4.3. If acquittal already been recorded, case involving moral transmission or offense, heinous crime, official on technical grounds is not case of acquittal. Benefit of reasonable doubt has been given. The employer may consider all relevant factors available to the antecedent and may take appropriate decisions according to the employee. In case where the employee has made a declaration truthfully of a concluded criminal case, the employer still has the right to consider antecedents and cannot be compelled to appoint the candidate. In case that can be truthfully declared, verification from the regarding pendency case, tribal nature, employer in fact conclude the case, in his discretion may appoint the candidate subject to the decision of the case. Each case, in case of deliberate suppression of facts with respect to multiple cases, such false information by itself has significance and employer may pass appropriate order, cancelling the candidature or terminating service for appointment. If criminal was pending but not known to the candidate at the time of filing the court, still may have adverse effect. In case employees confirm with service for determining suppression of false information, attestation verification form has to be specific, not vague. Only such information which is required to be specific mentioned has to be disclosed. If information was not up to the knowledge of the employer, the same can be considered an objective in the question of fitness. However, in this case, action cannot suppression of false information. Knowledge of fact must be attributable to him. 38.11. Still is the government has discretion to appoint him or not to appoint him. He may have been acquitted from criminal case.
Nothing, well.
Three judges with judgment, and Satish Chandra Rao also three judges with judgment, and Pawan Kumar is also two judges judgment. But it was prior to after 22nd May 2020. Pawan Kumar was delivered on 2nd May 2022, but Satish Yadav 26th September 2020.
Yes.
I submit one thing, my lord. My lord, in respect of the Satish Kumar Yadav, my lord, Pawan Kaur was discussed, my lord. My lord, kindly come with one, paragraph 63, my lord. Number one, my lord. And my lord, so far as Avtar Singh is concerned, my lord, in the Honorable Supreme Court, my lord, summarized the entire process. And my lord, he had also, my lord, in a case of tribal in nature, in which conviction has been recorded, such as shouting slogans at young age or any petty offence, which he, if disclosed, would not have rendered an incumbent unfit for post in question. The employer may, in its discretion, ignore such suppression of fact or false information by condoning the lapse.
Where is the prayer in your first way? Can we see the prayer in your first way? First way you have filed. Where is the prayer?
First way, my lord, I prayed for my lord appointment, my lord.
Where is it?
That first way is not recorded, my lord, here, my lord. Well, I prayed for my lord appointments and
You have a copy.
no, it is not with me just now, my lord. But only my
In
lord,
the first way, they did not file any reply.
no.
No, tribunal said that without, because.
Yes, we have seen.
That,
So issue of law, therefore,
no,
But my
that
lord,
issue
it was
from
disclosed
the
that criminal
state
case
of
was.
West Bengal.
that's why tribunal said it's pure issue of law, therefore a reply is not required.
My lord, in the first way, my lord, I have disclosed that criminal case is pending.
Show us the first way.
Then, my lord, I have to obtain certificate and I place before your lordship, my lord.
You come with it.
Thank you. Allow me 15 days at least. I'm obtaining
15 days.
certificate copy is required to an obtain.
No, your client have got.
Your client should be having a copy.
May not be, my lord, since my lord.
All right.
But allow me.
The learned
Number 3.
Lordship, I am for the petitioner in this matter. This is my affidavit of service. Lordship, on last occasion, yesterday, the state was there, Lordship. The Lordship asked them to bring some information regarding the service rules. This is the case, Lordship, where the petitioner was convicted in 1991, where he was in service, Lordship. And due to his conviction in 1992, he was suspended by disciplinary committee. And later on, in 2002, Lordship, he was acquitted by this Honorable High Court. And in 2005, he has been superannuated. Later on, Lordship, the petitioner claimed for his retirement benefit. His provident fund and gratuity has been cleared, but the pension has not been started. That is why the petitioner went before the tribunal. Tribunal rejected the application on the ground that the disciplinary committee, the order of the disciplinary committee has not been challenged, Lordship. Now, Lordship, the there was no separate disciplinary proceeding. There was no charge sheet, no proceeding, no inquiry committee, nothing. After conviction, only one page later, Lordship, the disciplinary committee suspended the petitioner. All I have annexed, Lordship. On last occasion, state was there, Lordship, on yesterday. But today they were not here, Lordship. Lordship, kindly come to page 27 of my petition for once, Lordship.
Where is your counterpart? Why she is not here? Yesterday,
Yesterday they were there, Lordship.
we asked them to show the service rules.
Service rules, Lordship, regarding under which provision they have terminated the petitioner, Lordship.
Yes.
Because there was no separate disciplinary proceeding. There
It was only based on the
only based on the
conviction in the criminal.
It's 27 for once, Lordship. This is the order.
So therefore, we wanted to see that
Lordship.
because
Yes.
once the substratum for the order passed by the authority is gone, then what does the rule say? Automatically he is to be reinstated, or what is it? You have to make an application, or a fresh order has to be passed after consideration.
That's your Lordship was asked them to.
You have not examined. You could have examined.
Lordship, regarding Lordship the rules, Lordship, I am not.
Bengal service rules. Service rules.
Sorry, my lord. I was just coming from another court, my lord.
No problem. No problem.
I am appearing for state, my lord.
Good.
Lord, last occasion, yesterday, the matter was taken up.
Which rule provides for
My lord.
automatic?
My lord, my lord, my lord. This is the rule, my lord. Rule 5, my lord.
5.
I'm giving, my lord.
No, we have the service rules.
My lord, this is, my lord, police regulation, Calcutta 1986 rules, my lord. It is, my lord, power was there, my lord, as per section 9 of Bengal Act 4 of 18866. My lord, disciplinary proceeding and punishments provisions are there, my lord. Kindly see this, my lord. Really, kindly see this, my lord. May I read it, my lord? যাও তুমি অন্য কোর্টে চলে যাও আমার নামটা লিখে দাও ঠিক করে
No, you are relying on 5.
Yes. My lord, apart from that, my lord,
What is the effect of an acquittal by the appellate court? That we are asking you.
my lord, I'm always bow down before your lordship, but my lord, rule says this, my lord.
No, that is over now.
My lord, basic
stage is
difficulty is this, my lord. Another, my lord, it is, my lord, new amendment of West Bengal service rules, my lord, part 1 and part 2, my lord.
Yes,
It is, my lord, section 7, my lord.
this is what we wanted to see. Rule 7.
Rule 7, my lord. Acquittal by criminal court, the head notice. Acquittal does not automatically give him the right to be reinstated into a service. My lord, here, my lord, apart from,
Rule 7 of
my lord, kindly see this, my lord, take this. In Joseph Category.
West Bengal service rules.
Yes, yes.
Rule 7 says age on first appointment.
My lord, head notice, my lord, chapter 3, my lord, disciplinary proceeding, dismissal, removal, stroke, termination of service and suspension. This is chapter 3, my lord. And I am on, my lord, page 75, rule 7. It is not automatic, my lord, subject to kind correction of your lordship. P76 and incorporating moral turpitude. So, my lord, it is the authority, my lord, subject to kind correction of your lordship, who will decide this, my lord, who will take a decision. My lord, difficulty is this, my lord, in this case, my lord. Your lordship, my lord, last occasion, my learned junior submitted before your lordship is this, my lord. Date of acquittal was, my lord, 21st May 2002. In the year 2002, my lord, petitioner got acquittal from this case. My lord, date of retirement, my lord, was 31st of January 2008, after a lapse of 8 years. My lord, it is not possible for the authority to find out who and who will be retiring from state service throughout the West Bengal. It is not possible. So, my lord, if the petition, it is the duty of the petitioner to inform the, my lord, concerned authority. In this case, my lord, petitioner sat tight over the matter. And after a lapse of long year, my lord, in the year 2021, 13 years gap, my lord, petitioner informed the authority. So, my lord, it is not the duty of the employer to knock the door of the every employee and inform me the date. It is not possible, my lord. And, my lord, if your lordship kindly takes the prayer before the tribunal, page 23, your lordship will get, my lord, two-folded prayer was there. An order directing the respondent authority to consider the representation dated such and such. So, my lord, prayer was for consideration of the representation. And second prayer, my lord, page 24, an order directing the respondent authority to take a decision in respect of the letter that is representation dated 7th February 2021. So, after a lapse of, my lord, 13 years, petitioner deposited their representation. And, my lord, I think, my lord, this petition should be dismissed, my lord, at the very threshold on the ground of delay, my lord. Limitation. No explanation was there, my lord, before tribunal. 13 years, my lord. And, my lord, some pensionary benefit like, my lord, GPF, leave salary and group insurance, already, my lord, state paid, my lord, as a good gesture, my lord. It is admitted position. It is admitted in the writ petition, my lord. So, my lord,
This is a 22 edition. This is not a, there is no amendment. It is only a 22 edition. I think provisions are not telling. May proceeding dismissal. Service rules. There is an amendment in the service rules, or is the same service? Why there is so much of difference between the two books? Chapter 3 here it says disciplinary proceedings. We just put this very old book. Amended, new amended. This is not telling. No, this you are reading is some case law. Where is the provision we are asking? Rule 5.1. 5.
rules 4 and 5, my lord.
Huh?
I submitted rules 5, but kindly consider rule 4 and 5. Yeah, বলেছি দর্শক, বলেছি।
No, you are relying on 7.
My lord, on that book, from that book.
Yes.
And from this rule, my lord, police regulation.
This 7 is not a rule. This 7 is a case law.
Yes, my lord. I am relying upon
Which
this
is the
rule, my lord,
rule?
this regulation, my lord.
That regulation does not contain any provision regarding effect of acquittal. That only says that based on conviction, they have to be removed. We are asking you which rule specifies what is the effect of acquittal by an appellate court.
Yes, my lord.
That's why we are unable to locate. You are relying upon a case law. There is not a provision. This is not rule 7. You are saying rule 7.
My lord, kindly.
It's not a rule. Chapter 9. Yes. Both of you are not able to assist us with the relevant.
My lord,
what to do.
if your lordship, my lord, takes, my lord, rule 72A 3. Rule 72A. Chapter 9, my lord, rule 72A.
Yes. 3.
A, B, these are there, my lord. But what I have
This is set aside by a court. This is not as a consequence of a finding in a criminal proceeding. This is not the relevant provision. This is when the dismissal is set aside by a court. This is not a question of dismissal being set aside.
my
It
lord,
is a question of acquittal being recorded in the criminal case.
Lord.
So what will be the effect of that acquittal? How he is to proceed under the rule? That is what we are asking you.
my lord, for this reason, my lord, I submitted, my lord, this citation, my lord, that is, my lord, page 75. What, my lord, court says, my lord, I placed before your lordship, my lord, in this situation. So, my lord, it is not a
And where is the provision for conducting proceedings?
my lord, that is, my lord, rule 5, my lord.
5.
Lord, that I have submitted, my lord, before your lordship, my lord. That's loose page, my lord. Police rules, my lord. Point number 4 and 5. After acquittal, my lord, I can proceed. Rule 4.
You have to give us a compilation of the relevant rules. Only we can proceed. Why you have not examined, sir?
Lordship, give me 2 days time, Lordship. Lordship, this is not a disciplinary proceeding was not initiated, Lordship.
How many times you will say that?
Lordship, they are stating that
That's why we are telling him that it is not a case of quashing of the
proceeding is on the
proceeding.
basis of conviction. He has
It
been-
is an order passed only based on the conviction in the criminal case. You said he has been convicted, you dismissed him. Now, as a result of acquittal, he says that he is entitled to be reinstated. What is the rule provision? It's automatic on his submission of information, or a review is to be done by some authority. We want to see what the rule
I
provides.
will examine, my lord, and I will come back in the next week, my
That
lord.
is what we asked
My lord,
for.
one thing, my lord, I must point out before this honorable court, my lord, difficulty was from the part of petitioner, because his date, kindly take notes of these dates, my lord, because, my lord, he was date of, my lord, date of acquittal from this criminal case was in the year 2002. 2002, and thereafter he approached before this honorable court for the first time, or made representation before the authority, my lord, in the year 2011 to 2021. 19 years back, he first made representations before the authority.
And what was his date of retirement?
And date of retirement was, my lord, 31st January 2028. Even, my lord, after a lapse of,
So
my
he
lord,
was still having about 7 years service left. That is a different thing. If he has come late, what he will lose out, how much he will get as a result, that is a different thing. But the point is, what is the procedure,
My
in
lord,
the rule?
we are always bow down before your lordship. I will, my lord, study and I will bring that rule. I will try my level best. But, my lord, here, my lord, fault, my lord, subject to kind correction of your lordship, my lord, fault was from the part of petition. Because, my lord, after a lapse of, my lord, 13 years, my lord, from the date of
That
retirement,
he
he
has
approached
said
the court.
actually his case is that
Authority was in dark.
he has become mentally unstable.
Lordship, I have never.
That is his case. There was a trauma and that resulted in becoming
That
mentally
may be, my
unstable.
lord. But that may be, but
So therefore, what he
my lord,
will lose for this delay, we will see. But what is the rule provision? When there is nothing against him, then what is to be done? Once the conviction goes and there is no proceeding conducted to find him guilty of any offense, or misconduct, then what is all we have to see is whether he'll be entitled to anything or not. For this delay, whether he will get anything for these 19 years or not, whether it will be counted as a valid service, break in service, we don't know. Therefore, we are saying, let us see what is the rule provision. Come with the rules, relevant rules.
I will. Lord, my learned junior is, my lord, trying my lord, it does not give any right to him in favor of him. My lord, kindly consider once, my lord.
Normal disciplinary proceedings, my lord, because disciplinary proceeding and criminal proceeding goes simultaneously.
ठीक है.
Here, that has not been done.
Yes, unless even if you had the discretion under Rule 4, you have not exercised that discretion.
That, my lord, I will come back with
You
instant.
have,
My lord,
but
yes.
nobody, you have not done so. So we don't know. At the moment, we don't know, but we must know at least what is the rule provision. Yes, let us
Item number 157.
Just reading the operative portion. The order of rejection date.
Item number 152.
Knew my prayer. My lord.
Yes, sir.
Can I come back tomorrow? My lord? Don't take me amiss, my lord. Whatever.
What is
has
this
happened.
point? We have fixed it at 2. You are saying come back tomorrow.
I will
What is the fun in doing it tomorrow morning?
My lord, I have
Why can't you do today? You have appeared on an earlier occasion.
appeared.
Only 1 year, 1 date prior to this. You have already been addressing us on merits.
For stay application, my lord, I require, my lord, some study. my
What study? Nothing. This is, we are just going. So once we have found a case for admission, we must protect him. Otherwise, what is the point in admitting the appeal?
Subject to my lord correction, my lord. Let me address my lord. Let me address your lordship, my lord, for my satisfaction. Tomorrow, my lord,
You will address. You will argue the matter before the honorable single judge.
on 10th.
Yes, you will. Why tell us why when we have found a case for admitting the second appeal, we should not protect him? You tell us.
My lord,
Is it a circumstance which can be countenanced by the court?
on that regard, my lord, I need to address your
No,
lordship.
therefore we have kept it today for you at 2 p.m.
Your lordship, kindly
Is
allow-
there,
Sorry, don't take me
have
as-
you heard of such a circumstance where
that-
the
my lord,
delivery of possession is hanging on
No,
the
that-
head of the
this
appellant?
is subject to.
We will admit the appeal and we will not protect him.
My lord, the thing is, my lord, what I will try to address before your lordship.
Yes.
Firstly, my lord, that for the stay is not a matter of right, my lord.
Oh, that all right. We'll record your submission.
That the thing is this.
All right.
It depends on the prima facie case. Is the, my lord, the key question, my lord, on that.
Prima
question-
facie case is we have found a case for
My lord,
admission of the
my
appeal.
lord, the judgment I have cited, my lord.
Yes.
I will advance my argument, my lord, on the
Tell us. You have already
the merit,
cited.
my lord.
Therefore,
Your lordship, if the thing is this, my in this matter, my lord, the appeal has been admitted, my lord, on the question which has been addressed by my learned friend, that, my lord, there was an earlier suit. There was an earlier suit, my lord, filed, my lord, for declaration that he is my tenant, and for injunction restraining, my lord, him from creating any subtenancy in favor of, my lord, one third party. In that suit, my lord, he has addressed. In that suit, my lord, I have not prayed for any eviction. Therefore, my lord, I have relinquished my right to pray for eviction, and I didn't seek any leave on order to Rule 2, and therefore the second suit is barred. My question is, my lord, it is absolutely, my lord, if in the earlier suit, the cause of action to sue him for eviction was my lord, the prima facie case, my lord, is depend on the chance of success. On the basis of the pleading also, my lord, I can show to your lordship. If your lordship hears me on that point, I can satisfy, my lord.
we are only on admission and an interim order. We
But the interim order, my lord, the thing is this, my lord,
are not going to decide the the second appeal right now.
my lord, the thing is, my prima facie case I am stating, lordship, the prima facie case.
So we have understood what you are saying.
The thing is, my
Yes.
lord, 2007, my lord, your lordship, kindly take the Premises Tenancy Act for once.
We are not hearing the appeal, sir.
My lord, in
Please don't try to argue the appeal. We ask you a simple question.
my lord.
that we have found a prima
In
facie
that
case
in that event
for
also,
admission of the appeal, should we not protect him or should we protect him?
my lord,
That's the
in
only
that
issue.
event also, my lord, the stay is in this case, my lord, is my lord, subject to payment of the occupational charges. My lord,
Very well.
yes,
How
and
can
the
can
occupation.
he say otherwise, sir?
But the occupational charges is not the contractual rent, but on the basis of that judgment, I can cite to your lordship
Yes.
that the fair rent,
Rent.
that the market rate.
That
The,
is-
on market rate, my lord, in that,
Why didn't you say during the morning? Why didn't you say earlier?
my lord, regarding that, my lord,
I submitted, I have to
Only
pay.
one claim do
yes,
you
yes,
have?
lordship, the market rate in that
You
area.
have learned counsel. You have only one claim, that is fair rent. Apart from that, nothing more to be said in this as regards to can.
So for the purpose of assisting on that, my lord, I want to produce certain document
Learned
that
counsel,
what
let us
is
hear what is the fair rent according to
in
you.
that area, my lord.
My
My
submission.
lord, that I want to bring.
Let him say.
May I just say in,
Let him say first.
My lord, on that regard, I want to bring on record certain documents, my lord, that what is the fair rent in that area.
then he
Within
has
the
to file affidavit. Because the reason,
otherwise, my lord, some guesswork is to be made, my lord. Your lordship has to make some. Your lordship has to make some guesswork for the purpose of ascertaining the guesswork, my lord. That's
What
why I have
documents
brought.
will you produce? What documents will you
Produce that in some website, my lord, in that area within 1 kilometer of the radius. What is the fair market rate,
What is the rent?
my lord?
being- learned-
It value
learned counsel, what is the rent being paid by the tenant now?
600, my lord, that is a contract 600 per month. That is a 600 per month.
350.
350 per month. That is a
350
contract
rupees,
per month, my lord.
350 rupees per month.
Now date
In
is at
respect of
3000.
learned counsel, in respect of how much area of land?
6 no, lot plain test. Plain test. Yes.
14 Chitak, 34 square feet.
My
Let
lord,
us take into consideration one,
my lord,
nearly 14 cheetahs.
yes,
One,
Two cutters, two cheetahs less than one
is
cutter.
my lord nearly 660 square feet.
660 square
Square
feet.
feet. The lordship, just for a
In-
moment, let me ascertain, my lord, from the plain itself, my lord. Otherwise,
In which PS? Within which PS?
my lord, it is my lord 664 square feet, my lord, within RS and Dak number, Kotian number, and Mouda Ichapur, police station Jogacha. And my lord, it is my lord, it's a commercial tenancy. Jogacha Howrah. It is a commercial tenancy. And my lord, in that area, what I have found out, my lord,
That you say.
the rent varies between 66 per square feet to 120 per square feet. But that is exactly what I have found, my lord. Your lordship, kindly see, I am giving a copy in that area within 1 kilometer of radius in 99 acres. I have found. Then my lord, even if the
99 acres.
yes, that is a commercial rent.
And he is occupying
64 square feet.
650 or something square feet.
99 acres is a website which my lord advertises the property for letting out and for the purpose of selling. In that, my lord, the most conservative rate for commercial tenancy coming to 66, and it varies between 66 per square feet to 120 per square feet. And my lord, one more thing, my lord, that if your lordship once I can produce a judgment, this fair rent is to be paid from the date of passing the decree by the trial court.
That will be decided by the
My lord, that has been, my lord, that is that.
bench.
My lord, that is,
Learned counsel.
my lord, that is a
Learned counsel.
I have taken the instruction because if I want to obtain a stay, 350 can't be. Now, my lord, the rate is in that area where I am occupying. Other area, 3,500 to 4,000 is the rate.
residential. It's a commercial
Please,
premises.
let me say.
You had the opportunity, learned counsel.
350, I am, if he want to contradict my lord, he can use an affidavit. But 350 was the previous rent. Now it is can't be 350. It is 3,500 to 4,000. The rate of rent.
So according to you,
এটা কোথায় ওইটা কোথায়
2017 it was my lord 350.
কেটে গেছে সবটা
I am increasing 100%.
মানে বল জায়গা খেপে যাবে এখন
and you are claiming according to you,
66 per square feet into 660, মানে it's a commercial tenancy. What my learned friend is saying is
what
a
is the
resident
net amount coming?
net amount coming আরে আমার নোটটা কোথায় গেল 66 into 664
42,000. This can't be.
But that is the
Personal limit.
that I have found. What I have found, and I am not making any submission on my assumption. This is the advertising. This is the advertisement given in the website.
Go before the
That
single bench and have it sought out by having commissioner appointed.
but even if
Chartered value or not
Malad,
Chartered valuer
and my
all
lord,
appointed.
and my lord, the thing is, my lord, the rent is to be paid from the date of the decree. That my lord, there is no more recent decree. I will cite two judgments, my lord. Your lordship consider. If your lordship thinks that this is
That
not,
will-
my lord, that is a settled principle. My lord, the contractual tenancy, my lord, severed the moment the decree passed by the learned trial judge.
You are well aware
Yes,
that we are passing interim order, that application is not being disposed of herein. Is it being disposed of?
no, my lord.
So
My lord, after the admission, the question comes, my lord. I was under the impression your
it
lordship.
will be
It is
only an interim order.
lord,
Apart from that, there
that's
is
why, my
nothing
lord,
more or nothing less.
that's why, my lord, I found out this one. Your lordship kindly see. If your lordship don't see that, then I cannot substantiate my claim. This is the thing I have collected, my lord. I have under impression that
Please see, you are claiming 42,000.
but this is what I am not claiming. This is the thing what I have found out, but I cannot make
That
any.
has been sought out before the single bench.
But let it be sent back.
From
My lord.
Google map, what he is showing.
Google Map. This is the.
You
it's
want
a
to
commercial-
determine, you want to determine the fair rent on the basis of an
But it is-
advertisement
But it is not a
published on a
it is not
commercial
but
portal.
it is not a fair. It is a market
Is,
rate.
can that be a basis?
My lord,
Has anyone responded? Has anyone paid? The advertiser may ask for X
my lord, what has been
amount.
My
That
lord,
will
what
not
has been-
become an amount which is the fair rent for that
my lord,
area
my lord,
or
what
the
has,
market rate for that area.
my lord, what has-
Cannot be.
my lord, what has
It's
been.
unsustainable.
My lord, I am not.
This is just an advertisement.
But
You are
I am-
relying upon an advertisement.
But I-
We thought you will come forward with something concrete.
My lord,
You have just taken a printout from an advertisement and you are showing
and
it.
my lord,
That cannot be
my
relied
lord, my
upon.
lord, in the fine morning, the appeal has been admitted and the my lord, application has been taken up for you. I am not ready. That's why I told you, lordship,
On
kindly.
You have argued on an earlier date. Today in the
But it
morning,
is
you
on
have
the-
asked us to record your
My
submissions.
lord, that is on the merit of the appeal, not on the stay
So
application. my
therefore,
lord.
for stay, you have to prepare separately.
My lord,
Very
stay for
well.
the purpose of market rate. my
Very
lord,
well,
I can-
very well,
but
yes.
kindly see, my lord, for once, my lord. The thing is that my lord, the yardstick is what my learned friend could income if he, my lord, create a fresh tenancy. That's why, my lord, this is the law, my lord, and Anderson Wright has decided it, my lord. But that has been decided by the Anderson Wright judgment. Anderson Wright Anderson Wright judgment. अरे आगे तो कॉपी होता है देखिए অ্যান্ডারসন এখানেই আছে may I cite this
It is
judgment?
his own case in the place.
Not deciding.
Man, this is the occupational charge.
It is his own.
It is
case
an
in the-
occupational charge.
File your affidavit, it will be considered by the Honorable Single Judge.
It is his own case in the plain that the valuation should be 4,200.
You contest
I will
that.
tell,
No
yes.
problem. You contest that. In the meantime, for 3 weeks, there will be a status quo. You file your affidavit, it will be considered.
Day of execution, my lord.
Yes.
From may I cite only one judgment on this?
They are not deciding why should we look into.
From the date of the decree.
We don't know whether the court will allow you from that date or What? Now you have been heard. Now you have been heard. All right. All right. We'll see. Now we have heard you. We have heard you, sir. Now call the next case.
Item number 174.
On the last occasion, lordships were pleased. On the last occasion, lordship, the order dated 29th of July 2025, my lord. It had fallen from my lords.
You were to file an affidavit.
Lordship, on that day, my lord, due to my ignorance in the matter, my lord, we have already filed a supplementary affidavit where we had put on record, and my lord, on 25/9/2024, lordship, we had filed a supplementary affidavit.
After the order, 29 July.
No, my lord, prior to that, my lord, and those were kept on record by your lordship. My lord, on that day, I render unqualified apology, my lord, as my lord's officer, my lord. I could not recollect that it was filed, my lord. So, my lord, therefore, that order on the 29th was passed, directed me, but that was already
It was on record.
because, my lord, it had fallen on the last
And after due service upon the
it has been served. And they have also filed a reply. Reply, my lord. Like a reply, I'm going on.
They have done already. They have representation. Now that the impugned order is now, it is the 26 June.
What is the impugned order?
24th of April 2024, the impugned order was passed. Lordship will find at page 219 onwards.
Just tell us briefly what is.
My specific case was before the CAT, before the landed tribunal was that without issuing any administrative order, they suddenly stopped the salary. Number one. We highlighted that issue before the landed tribunal. At the same time, that a departmental
So they stopped your salary with effect from which date?
salary was stopped since January 2023.
And you were working on which post?
Presently, Chief Office Superintendent.
Not paid till date.
Not paid, nothing. ইয়েটা কোথায় গেল? আরে যেটা ওদের
So there is no order of stoppage of salary.
nothing. Charge sheet.
Then what did you do?
Well, I made the representation. There was
What is that?
there was an interim order passed by the CAT that no adverse steps should be taken. Despite of that interim order,
Adverse steps. Why?
yes, Lordship, coercive steps.
For what?
Lordship, kindly
This is a
take
case
kindly-
of absence.
No, Lordship, that in the way, if your Lordship kindly take page 223 of my petition.
Can you give us a brief outline of what the issue is, the factual issue leading
The
to,
issue was that
yes,
I was found some neurological problem,
Okay.
diseases, and I was directed to visit the BRC hospital, the railway hospital. Thereafter, my case was recommended to the Bangalore, NIMHANS. The authority of the NIMHANS suggested that please give him a such type of place of posting where he should work with a group of colleagues. But I was given in such an area, in a lonely place, no group of colleagues. I intimated the respondent railway that please consider the recommendation of the Bangalore NIMHANS. Now, and since they did not consider, the OA was filed. And at the initial stage, when the OA was admitted, if your lordship kindly take page 223, and an order of interim order was passed. In the interim order, it was the land. I'm placing my lord the third paragraph, last paragraph of page 223.
no, you said you were asked to go to NIMHANS. Then what happened?
I went there.
Yes.
I visited there. On fourth occasion, my case was referred for the medical checkup. Now their case is this, that I was not found in the sick list. Now lordship knows very well.
Sick list.
Sick list, as they have used the words. Now, when regularly I went to for my checkup at BRC hospital at Kolkata, they did not take any signature from me. And suddenly, all of a sudden, they issued a letter that the incumbent is out of the sick list. Now, considering that letter,
What is a sick list?
my lord, kindly take. sick list থেকে আমাকে বার করে দিয়েছে ওই পাতাটা দেখো if you lordship kindly take page 26 of their opposition, that is annexure R2.
Which page, sir?
Page 26 of affidavit in opposition.
Page 26.
R2, annexure R2 of the.
Yes.
Yes. In reference, my lord, I'm placing, subject the re-medical examination of Sri Honorable Datta, Chief OS KRP. In reference to above, you are hereby intimated to advise Sri Honorable Datta successor to join duty at his current workplace on and from 18/12/2021, or as applicable and as per instruction of the Chief Specialist BRC Hospital. Again, you are intimated to send the joining report to the office of the undersigned at the earliest. Then, my lord, the copy of the remarks of the Chief Specialist BRC is attached herewith. Now, my lord, kindly take the next page.
We asked you what is a sick list.
My lord, kindly take the next.
My lord, that is that
Kindly take
page.
the next page.
May I assist, my lord? Look, that is at page 76 of the affidavit in opposition, which refers to the medical examination of members railway claim tribunal. That these are. My lords have come to page 76. Lordship will
76,
find the
yes.
sign medical certifications. Under that, Lordship will find in 537, these are the certificates which are issued by us. If a person is on under any sickness, a certificate issued and he has to report to the medical doctor at regular intervals, which has been enumerated at page 77. If your lordships may lay your lordship's hand at page 77, that is 1, 2, 3, 4, 5th paragraph, that is marked at 6. If my lord, at page 77, may I be allowed to read, my lord? The submission of sick certificate as prescribed in subparagraph 1 to 5 above shall be tantamount to only an application for leave of medical certificate and shall not be held to carry with it permission to quit the station unless such permission is expressly given by the competent railway. Then, my lord, which is very important, note, a railway employee who is placed on sick list, this is what we are on. Because a person who is regularly visiting our hospital he is not joining his duty, is put on the sick list. So his salary is continuation is paid. Why? How he is put on sick list, Lordship? Railway employees placed on sick list by a railway doctor should continue to report to him when fit to travel and send intimation about the condition if he is bedridden at such intervals as directed by the railway doctor. If a railway employee fails to do so, he is liable to be discharged from sick list and for non-attendance. Now, Milord, I will amplify after my learned friend. This is my case, Milord. He did not go and regularly visit BR Singh Hospital, nor did he go to Nimans.
No, but he is saying that there was no order passed and salary was stopped.
I shall. My lord, let him place his case. My lord,
Yes.
I just, as my lord's officer, because he was unable to show the exact pagination and
Very
the
well.
document which my lords were wanting to. Therefore, my lord, let him place his case, my lord, then I will try to befittingly reply.
Did you ask them to pay you salary?
Yes, I made the
They
representation.
have rejected.
They have not considered that.
Where is your, that's why we are asking, where is your representation? Let us see what is your anxiety.
যে representation or salary দিতে বলছে পেজ নাম্বারটা বলো yes my lord kindly come
Yes.
page 82 of my application of my petition. I made the representation to the senior divisional personnel officer, divisional operation manager, medical director, BR Singh Hospital, Eastern Railway. Now, my lord, this representation was submitted pursuant to the interim order passed by the Learned Tribunal. This was submitted on 11th of April 2023. From 1st of January 2023, from January 2023, the salary was stopped. Now, my lord, after getting such representation, on 11th of April 2023, they already issued a charge sheet, which your lordship will find at page 91. On 24th of April 2023, 91. Now, my lord, admittedly, I'm not getting any subsistence allowance.
Yes, let us see your prayer in the way. Where is the prayer in the way?
Wait. Prayer of the way. Your lordship kindly take page 52. Another relief sought for. An order to issue directing the respondent authority to strictly adhere to the opinion of medical board conducted on 2/11/21 by Nivans, Bangalore, with regard to the working condition of the applicant, ensuring his working with group of colleagues, and also to allow him to discharge his duty in the post of chief OS at an appropriate place under the respondents at an earliest. An order to issue directing the respondent not to adjust the period of treatment of the applicant at Nivans, Bangalore against the leave available in his credit, and thereby directing the respondent to regularize the said period at earliest. Communication letter dated such as issued by the respondent number 4, such as issued on behalf of the respondent number 2, office order dated 3/4/2023, along with the forwarding letter dated and the charge memorandum dated such and such issued by the respondent number 3 are not tenable in the eye of law. And order do issue directly the respondent to comply with the solemn order dated 27 April 2022 passed by the Honorable Tribunal, and they have directed respondent to allow the applicant to resume his duties in his post of CSOA, Kishorpur Railway Station, Eastern Railway, Murshidabad, in adherence to the opinion of medical board conducted on 2/11/21 by Nimans, Bangalore, with regard to the working condition of the applicant, and thereby making payment of salaries on regular basis, along with grant of arrears at an earliest.
And any assessment has been done by the railway authorities, the medical facilities of the railways.
No.
Apart from Nimans, there is nothing.
No, 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 no.
And why have you proceeded like this? You have invited this situation. For years together, you are absent, and then you say, Nimans has asked me to work in a group, you post me in a group. Can this be done?
No, regularly I visited the BRC hospital.
You may say so. That's all. At best, you can say so.
Yes, I regularly I
There is
visit.
nothing. We asked you, show us one piece of paper by the medical facilities in the railways. You may have visited. That's not the point.
Lordship, kindly take. My lord, my simple point is this:
Since when are you absent? Tell us.
when I was paired for the medical examination
Yes.
in the year 2022,
What is date?
2022,
June. Which June?
আমাকে স্পেয়ার করলো সেই পাতাটা দেখাও। If you'll also kindly take page 67 of my application. My lord, this was the first for medical examination, re-examination to the Nimans Bangalore. Then, my lord, kindly take.
This is the first reference.
Yes. Thereafter, page 69. Well, this was issued by the BRC Hospital at page 69, wherein they opined. Let's kindly take page 69. The last paragraph, the above named employee appeared for re-medical examination from senior DPO Sealda, wide reference regarding determining his fitness, suffering from anxiety disorder. The employee was evaluated at psychotherapy OPD BRHA and referred to Universe Bangalore for further treatment and management. A medical board in respect of such and such was held on such and such, wide such and such. Now medical board dated attached.
This page 67 that you have placed, it is for a review. That means you have gone earlier.
Thereafter page 69, I'm showing one after another document. I'm showing one after another document.
This is subsequent.
But three times I went to Nimans Bangalore as per the recommendation of the medical board conducted in the BRC hospital, which my authority knew very well. Now, all documents and letters which they have served upon me while I was for the medical test at BRC hospital. Suppose, my lord, I am showing one document. My lord, I have already shown your lordship that on 11th of April I made a representation.
No, they have there is no assessment. There is no assessment by the medical officers in the railway.
Lordship,
there is no assessment of this condition by the railway doctors by the railway doctors.
Yes, it was considered. That's why my case.
Show us. We are not able to find. They are all relying on something which Nimans has said. Perhaps you have got yourself checked up. You have come and said that, look, this is the advice. They say, all right, you go for a review. They say, we'll not reimburse your travel and all that. That is the rider at page 67. Again, you go to them that the board has suggested. So again, they ask you to go and get the opinion from Nimans. Can they rely on anybody's board opinion, or they have to form an opinion for themselves before they proceed to grant the benefits admissible to you, if at all, by virtue of the condition that you are claiming?
The doctor of Krishnapur Health Unit, wherein I was posted, the railway doctor,
Which page, sir?
page 70.
70.
70.
This is also relying on Nimhans.
Yes, on the basis of the demands.
There is no assessment by the medical officers. You have come to them with reports from Nimhans saying that, look, this is what they advise. They say, all right, you go and get yourself reviewed as and when you want. They are not even reimbursing you.
So, my lord, during
So
my posting
therefore,
at
relying on this, can they act or they
No,
have
my
to
lord,
make their
my
own
lord.
assessment?
one thing I am showing, Lordship, if your lordship can take the office order of the assistant personnel officer at page 89. As per their recommendation, as per their order, I went there for my medical examination. But this office order is issued is to be treated 3rd of April 2023. From 3rd, they stopped the salary from January 2023. Well, this office order shows that Honorable Social Suggestion employee is to be treated absent from 23/6/2022. Medical examination 2023. Number on 23/6/2022, I was before the BR Singh Hospital.
So after that, you have not never worked. You have taken a reference for Nimhans and thereafter every
No,
period.
thereafter, they issued that charge sheet, charge memo they were issued.
That
did
has
not-
come later. That has come
that
later.
that was
That has
passed
come in
later,
April, 3 months after that.
after 3 months after my stopping
Yes.
of salary. And they intentionally did not issue any spear memo. আছে তো যে আমাকে দিতে বলছে হ্যাঁ এটা কি বলছে only one allegation they have got. It is my duty to.
You were spared on 23/6/22. Is there any order?
No, they did not issue any spare order, but I was spared. It was reflected in their order. Only one issue they have raised.
23/6/22. There is no order.
No order. But Malad, kindly see if you also kindly take page 80.
That's what we are reading. Therefore, we are asking you. See the second paragraph. They say that you were spared for medical review under so and so on 23/6/22.
Now they have made an allegation that on 14th I refused to attend the repeat checkup.
We are asking you to show one checkup by the railway authorities. You are not able to show one. How do you proceed? How expect them to proceed to consider you as a sick person? And how can you justify such long absence from duty?
If you want to kindly take my medical checkup report, page 62, kindly see, issued by the BR Singh Hospital, 62, 63, regularly my medical checkup were going on. Treatment.
They have found only you that you are suffering with some anxiety. They have not found any such condition which you claim from Nimans.
No, I did not claim. They referred my case to the Nimans.
Let's see. It doesn't look like a reference. It appears that you have earlier gone to Nimans, then you have come back to them, then they have allowed you to go again.
my lord,
It's not the reference. It's perhaps on your request. The first one you showed us is at page 67.
page 67.
Now just read it, please.
Critical note, my lord, page 60. At present, table.
No, a case of anxiety disorder diagnosis from Nimans of 3/3/2020.
Yes.
So you wanted to go back, they said, all right, you go and look, it says the charge in this regard will be borne by the party himself. You are trying to say that it is the railways who have come to an assessment and finding it necessary sent you to Nimans. But the document doesn't support such a submission.
But they referred the hospital.
Because you are going there for treatment before on 3rd of March 2020. It refers to an earlier diagnosis of 3rd March 2020 by Nimans.
My lord, medical check.
And therefore they are allowing you to go for review opinion. It's not for checkup.
My lord,
You see what it says at page 67. It says review opinion.
my lord, kindly again, lordship, I am traveling to your lordship. Again, to come back page 62, 63 and 64. Regularly, my case was I was referred to Nimans. I went there, visited Nimans. Medically, their medical checkup was done. Thereafter, again, I returned back.
What is the date? Page 62 is dated?
Page,
This is of January 21. This is of a much later date.
but prior to that, my case was under their consideration for the treatment.
Now you please come to page 67. You are at Nimans since March 2020. Much before this 21 document that you are placing at page 62 or 63. You say that Nimans has advised me this, you to act accordingly. So what has the tribunal directed?
Tribunal directed to consider the representation and to pass a rescind order.
That has been considered. Therefore, my lord, my lord will give me 30 seconds, my lord. I will put everything that
What happened on his representation?
my lord will kindly take up just 30 seconds, my lord. It will cut short the story. My lord will kindly come to the prayers.
Yes, we have just seen the prayer.
Yes, my lord, at page 21. Lordship will kindly see.
52.
Page 21 of the petition.
Yes.
My lord, they have challenged the order of the tribunal dated 24/4/2024,
Yes.
saying that it should be modified to the extent that while my representation is being considered, the salary should be started. Now, my lord, this representation has been considered and an order has been passed which forms part of my supplementary affidavit.
Yes.
That was in the month of July. As per the tribunal's order. So, my lord, now the tribunal's order has reached a conclusion. Supplementary affidavit. My lord will kindly come to the supplementary affidavit which has been affirmed on 25/9/2024. Lordship will kindly see R9. My lords have got it.
Yes.
My lords will
26.
kindly see 26/6/2024.
Yes.
Considering of representation which was again showed by him to my lords. Now, my lord, this is as per the order of the tribunal, my lord, which is at page, the tribunal's order. If my lords kindly come. To the order impugned.
Yes.
My lord, can you bear me with it? My lord, that is at page 219.
Yeah, we have the impugned order.
Lordship will see the impugned order, the relevant portion. Here, all these points have been taken into consideration. And my lord, 2022, 222 page, my lord. Paragraph 8 specifically says, therefore, we are of the considered opinion that the grievance of the applicants need to be examined by the competent authority as per the contention of the representation. It is expected that the competent authority will consider and decide the pending representation of the applicant in accordance with, to the extent of service record expeditiously, not later than 60 days. Now, my lord, this has been considered and allowed. And what representation he was saying, my lord? The representation, my lord, he had already placed before my lords, is at page 82. Now, this, my lord, representation takes into its ambit all the orders which have been passed by us, including our charge sheet, everything, show cause, everything. Now, my lord, this particular representation was made. Subsequently, an OA was taken into, OA was filed before the learned Central Administrative Tribunal. Now, while considering all the prayers in the OA, which was placed before my lord.
So the charge sheet had already been issued prior to.
My lord,
filing
charge sheet, we have not come to a final. Yes, my lord, it has been. My lord will kindly see the OA prayer, if my lord kindly allows me, what was being placed by them. If my lord kindly comes to page 52.
Yes, charge memorandum.
My lord will kindly
Dated
come to page
24
52, BB prayer.
24/4.
My lord, 28/12/22 is page 45. That is the where we have said that you have, if my lord kindly allows me to place page 45. Communication is at page, my lord will kindly bear me. It is not at page 40. My lord will kindly, I'm giving my lord the wrong page number, my lord. I'm coming to it. My lord will kindly bear me. My lord will kindly come to my AO, affidavit in opposition. I stand, my lord, I apologize for the abbreviation, my lord.
Yes.
Now, my lord will keep these two side by side, page 52 of the main petition, and my lord, my affidavit in opposition. Now, my lord, the first letter which they have challenged, that is 28/12/2022, is at page 45 of my being R4. Now, my lord, what we say, my lord, I would intend to put before your lordships. This is for your information that Sri Onimesh Doctor, so-and-so, was under regular treatment from psychiatry and Nimans, Bangalore for psychiatric illness since 2019. He appeared for re-medical, and after detailed consultation, he was advised to review checkup every 6 months to pursue his duty from Nimans, Bangalore. According to Onimesh Doctor, attended Nimans for medical bed on 3/3/2020, 17/6/2021 and 2/11/2021. However, on 4th instant, he refused to attend a review checkup. The employee is not in the sick list, and at this end, and his whereabouts are not known. Now, my lord, they knew he has to go to the BR Singh hospital. Then only he will be put on the sick list. If he is on the sick list, it will be deemed lordship that he is still in service. Because of his sickness, he is not joining his duties. Now, my lord, he cannot show a single document before your lordships that he has gone to BR Singh hospital post 2021. Now, my lord, the second in OA, my lord will again come to page 52 of the main writ petition. The second order, which office order which he has challenged, is 4/1/2023. My lord, BB prayer. Now, my lord, that I am placing before my lord, that is at page 46 of the affidavit in opposition. Here, my lord, we specifically put on record that what he has not done, which was within his knowledge. Now he is asking for, in January 2023, when we stopped the salary, this for the reasons which was within his knowledge, otherwise he would not have challenged that in the OA. My lord has got this letter 4/1/2023.
Yes.
Now, my lord will kindly allow me to place paragraph 2. Further feedback was received by the office that this office and Sri Dotto did not join duty till middle November 2022. A letter dated 28/11/22 was sent to the chief specialist BRSH, that means BR Singh Hospital, Shialda, with the request to inform this office about the status of the medical review of Onimesh Doctor. Then, You know, the office received a copy of the letter dated 2012-2022, reference so-and-so, requesting the medical status of Sri Onimesh Dotto, so-and-so, who was spared for medical review under so-and-so on 23/6/2022. The letter from CS BR Singh Sialda dated 28/12/2022 was received by this office on 30/12/2022, stating that Sri Dotto attended Nimans for medical board on 3/3/20, 17/6/2021 and 2/11/21. However, on 4th instance, the concerned staff refused to attend the review checkup, and therefore the employee is not on their sick list and his whereabouts is not known to them. Now, all these documents were with him, which he challenged before the tribunal. Now, the tribunal gave an order, rightly, wrongly, indifferently, considering all these aspects which he's trying to impress before my lords very humbly. And there it culminated into an order which is under challenge, which says that consider his representation. We considered his representation, we have passed an order. Now, my lord, if any order even is to his detriment, he has a definite cause of action challenging that order before the tribunal. Now, my lord, will kindly see page 50, the second prayer, my lord, which is before your lordships. Now, 21, my lord, will kindly allow me to come, page 21. So, my lord, the first prayer has culminated to a logical conclusion, this order of 24/4/2024, which is under challenge partly. Now, my lord, that has come to a logical conclusion because we have considered and we have disposed of the. Now, my lord, the second prayer is that the charge sheet. Now, my lord, I'm asking a question to myself very humbly, that a charge sheet is to be. It is still going on. We have not terminated him. It's still to come to a logical conclusion. If at all this charge sheet needs to be challenged, it can be challenged in two modes, my lord. Before the tribunal or before a honorable writ jurisdiction on the ground of arbitrariness and other principles of natural justice or the cardinal principles of jurisprudence. These are the only two remedies available to him. Now, my lord, before this honorable bench, where he is primarily challenging the order of the learned tribunal passed on 24/4/24, has come to a logical conclusion.
When
Now,
is
my
the reasoned order passed on?
lord, my lord will kindly see the supplementary affidavit, my lord, and they have not challenged that order as of yet, my lord.
That is R9.
Lordship.
What have you said in that? What have
My
you
lord,
done?
we have said whatever I have put before my lord. My lord will kindly give me another 1 minute just as to what happened. Now, my lord, this particular gentleman had certain psychiatric problem. That head office is Nimans. He got a certificate for Nimans and he was under treatment at BR Singh Hospital. Every 6 months, he has to review from Nimans that whether he has become okay or not. Till that time, we will pay his salary and we will put him into a particular place. But until and unless a certificate is given. Now, my lord, what he did out of his own whims and fancies, from last time he went to Nimans is 2021. Then after that, he said that I am neither going to go to the BR Singh Hospital nor I am going to Nimans. So on his own whims and fancies, he says that I am not going to go there. Now, my lord, I had placed before your lordships when my lords were asking me where is that railway rules, which my learned senior friend could not lay his hands on. There, my lord, in the note, it is specifically mentioned that you have to regularly go to the hospital to be on the sick list.
Continue to report.
Now, my lord, he has not reported. So, my lord, and all the memos which I have placed before my lord, page 45 and 46 of the AO, goes to say that you, after 2021, you are neither getting any certificate for Nimans, nor you are going to the BR Singh Hospital, and neither you are joining your duties. So, my lord, and then you are coming and telling that my salary is not. And, my lord, what interim order was passed by the tribunal culminated into this final order. What he was placing, if my lord allows me to come.
Now their OA has finally been disposed of. Now
Finally disposed of, my lord. OA was disposed of, and culminating into that, we have considered the representation. My lord, the OA was disposed of, lordship, by order dated
24/4.
Lordship.
24/4/24.
Lordship. So, my lord, and the interim order which my learned friend is trying to impress very humbly before your lordship, that was prior to disposal of the OA. Now, that interim order passed in 2022 has culminated in the last order. The OA, my lord, was disposed of on 24th of April 2024.
Yes, that's
And lordship will kindly see the interim order which we was placing at page 223, where he said your salary cannot be stopped, this cannot be done. That was on 27/4/2022.
has
So, my
to
lord,
be.
now, my lord, so on 22/4/2022, we did not stop salary. Admittedly, salary was stopped in January 2023. And now, my lord, whatever it is, my lord, this order has culminated into this order dated 24/4/2024. Now, my lord, rightly, wrongly, indifferently, the cause of action, a fresh cause of action has arisen for them. And my lord, factually also, my lord, I am just asking a question to myself very humbly, my lord, that a person will not go and present him before the doctor. He will not go and join his service. He will not go to Niman's. And then he will say, when he's out of the sick list, he will say that you give me my salary. And the challenge also which has been made by him, in all, he has the knowledge of all these actions which have been taken by me, because that forms part of prayer BB of his OA.
So how can he participate in the proceeding if he's not getting any subsistence
My
allowance?
lord will kindly appreciate. The issue is this, my lord. It was everything started, my lord, only when he, out of his own whims and fancies, did not go to BR Singh Hospital.
That we have understood from January
Now, my lord,
23, he was say he is absent.
yes, my lord.
He has not put himself on a sick list. He has not reported for reviews. He is nowhere. You don't know where he is. But the fact remains that you issued a charge memo. You want him to participate in the proceedings.
Yes, my lord.
Can you ask him to come without giving him subsistence allowance?
My lord, charge
Is it
memo, my lord.
possible? Is there such a situation is possible under any law?
My lord will kindly come to the charge memo first. My lord,
Yes.
if my lord allows me.
Because salary you have stopped. There is no denial of that.
My lord will kindly bear me. If my lord takes up the writ petition, page 91. This is the memo, this is, my lord, the charge memorandum. And, my lord, at page 94, lordships will find the articles of charge.
No, where is his entitlement to subsistence allowance? That we are asking. Can an employee be asked to participate in a proceeding without a subsistence allowance? Under any circumstance.
My lord, I bow down. What
So
is followed?
therefore, at least if you are not paying him salary, how can he effectively participate in a proceeding unless you pay him subsistence allowance?
My lord, may I come back with instructions, my lord, on this? Because, my lord, I was fighting tooth and nail on this point, my lord. That, my lord, since
See,
this
the
particular...
issue which emerges now is that since he is undergoing treatment for at least 2-3 years prior to what the precipitatory action which has brought him to the court. After 21, you said earlier we have been referring you after a particular date X, you are gone.
Yes, ma'am.
We are not to be found anywhere.
Yes, ma'am.
Therefore, you have started taking action or stopped paying salary to him. He says, look, I'm in such a condition, I have to keep going. He has a different story to say. The same gives rise to a charge memo. He is not being paid salary. How can he participate?
As far as, my lord, this petition before your lordships is concerned, and the prayers, my lord, contained therein, it has come to a logical conclusion because an order passed by the learned tribunal, while considering all these aspects, The learned Central Administrative Tribunal said consider his representation, nothing more, nothing less.
But then what has now what
Now, my lord,
happened?
we considered his representation, we have passed a reasoned order.
Now all
Now, my
his
lord, he should challenge that reasoned order.
but all his entitlement now hinges on what happens in the proceedings. If in the proceedings he is able to substantiate that he has visited the hospital, still there is no, it is not taken note of by the authorities. Maybe we don't know.
My
It
lord,
will not be proved. But if it is proved, he may have to suffer. But the point is, how will he participate?
my lord, in my respectful submission, my lord, that my lord, on that aspect, my lord, I may take instructions, but my lord, as far as even if it becomes in the writ jurisdiction, this cannot be proved whether he went there.
Cannot be. But there we are asking you, how will he participate?
R8 DOPT guidelines which says
At least I have not come across such a rule or any provision which says without subsistence allowance an employee may be proceeded against.
unauthorized absence will not be getting substantial.
My lord, what I have been assisted by my learned junior, my lord. If my lord kindly comes to the our in
See, the absence is the charge.
my lord.
You don't know whether the charge will sustain today. He also doesn't know that the charge will
My lord,
sustain.
DOPT guidelines governs us in some other way. If my lord kindly comes to page 146, which is my lord to our AO, affidavit in opposition. And my lord, we have amplified this annexure at page 31 of the AO at page 10. If my lord, I may be allowed to read that page 31, paragraph 31 at page 10 of my AO. The answering respondent humbly submits that the Railway Board had adopted the consolidated instructions on the subject of regularization of unauthorized absence issued by the Ministry of Personal Public Grievance and Pension, Department of Personnel and Training, wide OM number 13026, so and so, dated 22/6/2000 are enclosed. These instructions shall apply mutatis mutandis to the Railway Board. Now, my lord, here, my lord, kindly comes to consolidated instructions on the subject of regularization of unauthorized absence issued by the Ministry of so-and-so, 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 wide so-and-so. 3 instructions shall apply mutatis mutandis to the railways. The railway rules corresponding to CCS rules quoted in Department of... Now, Millard, here under these rules, Millard, no subsistence allowance, Millard. कौन सा कूट के देखो rules में दिखाओ यहाँ पर.
Will not
my lord, I'm amplifying, Millard. 148 में कौन सा था? My lord will kindly be, because we have amplified those rules at page 148. I'm showing it to my lords.
No, these are on regularization of unauthorized leave. How can it be regularized once you have made it a charge? Now it has to be seen whether it is a willful and deliberate
What has
absence
fallen
or
from
not.
my lord, what I could understand with my limited understanding, that if a subsistence allowance is not given and something you charge someone with something. Now, if he has to effectively participate, he needs something, some sustenance.
That is the whole concept of subsistence allowance.
Lordship,
Even
may I come back, my lord? With just one
yes,
thing.
you pay him
My
that.
lord, I have followed your lordships, what has fallen, my lord. Because, my lord, we were...
No salary.
See, when there is an unauthorized absence alleged, there are 2 or 3 options. One is that he has leave and he utilizes his leave in respect thereof. The other is he claims regularization of the period of absence under the rules, which is governed by the CCS 227, which you have shown from 147 to 48. The third is you say, no, this is an act of indiscipline or misconduct for which I will proceed against you. You have gone for the third option. Now you have converted that into a charge. Therefore, issue of regularization of the leave does not arise. The thing is whether it was willful and deliberate unauthorized absence or not, that has to be seen by you. How can you see it unless he participates? Therefore, we are asking you, and how you cannot compel him to participate unless you have paid a subsistence allowance. We don't think any rule would provide for proceeding against a person without paying
My lord,
subsistence.
I shall come, my lord, because what I have been told there is a rule, but then, my lord, I cannot make any submissions out of the cuff, my lord. At this aspect,
No,
my lord,
146 to 148 is for a different circumstance. That is for
my lord,
regularization of
I shall, my lord,
period of leave.
just, my lord, 1 day's breather, my lord, because all other aspects I have, my lord, already submitted before my lord. Since this has fallen, my lord, let me come with a clarification and then I'll address your lordships on that aspect. Because my lord is wanting me to say that subsistence allowance is there for the framing of charge. After you frame a charge or you start disciplinary proceeding against a person, in order to participate therein, he needs some subsistence.
Yes, otherwise.
And unless it is barred by law, any rules, that
don't
is
know,
to be
we-
shown to my lords. Otherwise,
We don't expect, but we don't know.
my lord, I also do. My lord's officer first time. I also don't want to make champion for a cause which
No,
I
no,
am
but
not
let's
very
see.
confident about.
You may check up.
Yes, my lord, I will check up. My lord junior has pointed out, but my lord, until unless I
48.
It's never suspended. That's why
इसको
suspension.
एक बार समझ लेना अच्छे से अभी यहाँ पर my lord, let us deliberate on it, because I want to come with a concrete submission, my lord. I cannot, my lord, I don't
Let
intend.
them find out. Yes, yes.
Short evidence.
No.
That is a fact, my lord. That has been served on him.
Because the two things are there.
What is it? Tell us.
It has the accident of the discipline rules.
Yes.
They have, I stopping my salary. That rule was written on the, under which rule they stopped my salary. And in my reply, I have get their obligations that I regularly visited the BRC officer.
We cannot go into that issue of disputed issue of fact. That can only be thrashed out in the inquiry. We have asked you so many times, show us one, because there is a possibility that this person is maybe not in the right frame of mind and that he has, for some reason, maybe a bona fide, we don't know for, but we have not one sheet of paper is shown so as to inspire any confidence in this. Otherwise, you want to file a, you can do it.
If I get my some documents after
Since we are adjourning it, you can do so. You will file a reply to
the supplementary affidavit.
My lord, that is, my lord, what we have done. Now, my lord, filing reply,
No,
my lord, I
only
bought a
just if I get some documents
document.
to show my bona fide that I visited the medical BRC.
Can we enlarge the records now at this stage?
Not that that's true, not. But since
Because the tribunal's order has to be judged on the.
since he is in such a position, his very much unbearable condition is going on, my lord. That's why I am praying, my lord. Only for.
My lord, even if
Not-
supplementary
So
affidavit,
therefore, there's no reply to be filed. If you find something, we'll see.
Lots.
because, my lord, whatever rightly, wrongly, indifferently, we have
No, since
passed an order.
charge sheet and
Now, my lord,
And
that
the charge
express-
memo for assailing a charge memo, the grounds are very limited.
my lord, he has neither assailed the charge memo, nor he has challenged.
He has assailed the charge memo before the tribunal.
You have assailed the charge
Yes,
memo?
24-4 he has assailed.
Yes, my lord. Yes, my lord. In 24-4, he has assailed.
Yes.
But, my lord, it has culminated into representation consideration.
So therefore,
Now, when consider
and not only that, it is on his submission recorded before the tribunal.
Yes.
That I have made a representation,
Yes.
you please direct for disposal of the representation.
Well, my understanding of the situation is once rightly, wrongly, indifferently, we have
But
considered
then everything said and done, how can he
subsistence,
participate?
subsistence and
How
all.
can he
Yes, my lord. That aspect, my lord, I am going to answer to your lordships on the next day. But then again, he's trying to expand or amplify the scope. Which, my
He's
lord,
trying, but let us see what we do.
Same thing. The amended the main, despite that we
अब वो कैट में जाके क्या होगा?
The
instruction which has fallen from my lord. But my lord, after this, my lord,
Now, after this, where's the
yes,
question?
that is the event now as it has unfolded, my lord. So, my lord, let him come, my lord, and we will come with all those documents where we will show that he has responded that letter, and my lord, that it has been served.
No, now he will have to challenge it
Yes,
appropriately.
correct, my lord. Kindly take me one, at least.
Either he will have to assail it before the disciplinary authority. He can take a ground that I could not appear for
Yes.
this
And is here, my lord. Kindly keep me just a few hours.
day after tomorrow.
পরশু দিন করুন না আমরা কেন সব হ্যাঁ হ্যাঁ ঠিক আছে
Item 175.
আই এম গ্রেটফুল
May I please your lordships, my lord? In terms of my
Have
lord,
you intimated the land?
in terms of your lordship's last order, my lord, my lord, I have intimated them, my lord.
He is not appearing, he is disappearing. Where is he? Ask him to come. He's coming.
But that is compliant.
Yes. All right.
Kindly have other dated, my lord. The 1st of August. In that order, lordship has
Any
been,
reply was filed before the
yes, my lord. They have used a reply, my lord.
here
There.
in the tribunal.
Yes.
Where is the reply filed before the tribunal?
My lord, it is at page number 1. My lord, 103.
What is the date of the government notification?
The lordship has been pleased to record all the dates, my lord, in your lordship's order, 1st of August 2025, my lord. Nevertheless, my lord, I will just,
1st August.
yes, my lord. My lord, date of notification of
All right, let us. You applied as a general category candidate. Yes.
lord, it's a judgment delivered by this honorable court, my lord, by your lordships, my lord. in which, my lord, the challenge was similar, that the reservation policy was not followed. The applicant participated in the examination process. They appeared in the written test, and thereafter, before the declaration of the result, after 4 months, my lord, they made a representation. There was inaction on the part of the authorities in considering the representation with regard to reservation, appropriate reservation, my lord. Then they approached the tribunal, my lord. The tribunal dismissed the original application. Thereafter, they came up before your lordships, my lord. Your lordships, in this particular judgment, my lord, has dealt with what is the effect of a violation of reservation policy, my lord.
The tribunal before declaration of result.
But my lord, this judgment. My lord, 2000. My lord, kindly consider the factual background is recorded at paragraph 3, my lord. Make the correction, my lord. My lord, may kindly see the last paragraph 24, where, my lord, the law has been discussed, my lord, after citing several Supreme Court judgments, my lord.
So here it was observing the reservation, but number of posts was in dispute. There were two, plus there the tribunal had rejected on the ground of maintainability. Here the
Because this is
tribunal,
also maintainability, my lord.
no,
In essence, my lord.
no, it has considered the entire thing. Yes, who is appearing for this? You have given a copy.
Confession, my lord, I'm not ready with the matter. I'm, my lord, seeking your lordship apology and my lord asking for accommodation. I will come back on tomorrow or day after tomorrow, my lord. Whenever you lordship, please, my lord.
Give her a copy of the judgment. Share it with her. The petitioner's counsel relies upon.
Two 2019 SCC Online Calcutta.
2019?
SCC Online Calcutta.
Hmm.
9250.
কোনো প্যারা আছে?
24. Grateful.
Item number 2.
This is my appeal, Millet. I'm a decree holder of eviction decree, Millet. But an application under order 21 rule 97 has been allowed. Millet, holding that party, Millet, has independent right, Millet. I'm against that order, Millet. But in this appeal, Millet, I had preferred an application, Millet, under order 21 rule 41 rule 27 for additional evidence, Millet. By my lord's last order, Millet, we were supposed to exchange affidavit, Millet. It's not complete yet, Millet. But I was humbly beseeching, Millet. This was also mentioned, Millet, a couple of days ago, Millet, that can it be fixed on 18th of September, Millet? This application, Millet, is for additional evidence, Millet, under order 41 rule 27, Millet. I have filed the decree holder, Millet. I'm pressing the appeal, Millet. My learned friend is supposed to file an opposition, Millet, which is not yet, Millet.
Not filed yet.
Well, it's almost ready, my lord. We'll just get it, my lord. We'll serve them in the course of this week itself. Well, this is the second application, actually, or third.
Then it will come the other side of the holidays.
I mean, my lord's hands, Millet, if 18th was, Millet, 18th of September, Millet can accommodate us. We can start on that day, Millet. 11th September, may I, Millet, beseech, Millet.
11th September, we have
difficulty.
You had said you are going to mention it.
Can we start on 18th, Millet? If my lord can give us some time on 18th, Millet. I mean, my lord's hands, Millet, ultimately, Millet.
Not possible this side. The learned advocate.
Last question, Lordship. Government notification.
Where is the order passed in OA 109?
109.
Which page? $50.
15, 15.
This is order.
What? 75, 76. 56.
And when has the employee died?
92. November 1992.
9th November.
9th November.
And when the family's pension has been sanctioned? Date?
November 2023. Lordship.
Where is that document? It's not on record. It is not part of the record.
My lord, it is the supply of the
Hello. My lord, two things, if I may assist your lordship by saying. First issue was with regard to res judicata, that your lordship has already considered. Now, what my learned friend had addressed your lordship was on the point where whether the petitioner is appellant here is at all entitled to gratuity or not. With regard to gratuity, I have only one submission. The gratuity was never paid in the original application twice. Two original applications filed. It can be presumed that gratuity was paid
at the time of his, after his retirement from service. There was no pleading with regard to gratuity. The only pleading
He
they
did
had
not retire. He took a
voluntary
voluntary.
retirement. At the time when the voluntary retirement was.
Is there any statement in the OA that he has
No.
not taken gratuity at the time of voluntary retirement?
Neither this way, neither that way. There is no averment with regard to gratuity. There was no prayer with regard to gratuity.
Have
If
you
I may-
said in the OA that?
Oh, it नहीं बोला.
Yes, my lord. My client, my lord, the original incumbent died 40 years ago. My lord, they belongs to tribal family, my lord. Therefore, the other family members have no documents about the payment of gratuity or not.
That's all right, but then how can you make a claim when you don't know?
But my lord,
Unless you know that you have not got, how you can make a claim?
yes, my lord, whether they received the gratuity or not, how much amount is due, only the state can say from their record, my lord. And my lord, in the OA application, the prayer is the interest on the area pensionary benefits.
Delayed payment of pension.
Delayed payment of pensionary benefits which paid after 32 years.
Only to that extent.
That is the only prayer.
Yes.
For interest.
Yes. And that was
Only
rejected. That was turned down. That is
all
why.
the benefits area had already been paid, but after 32.
Paid in 23.
Yes.
24 million.
23 or 24.
9/9/23.
Yes.
9/11/23.
9/11.
Or 10/11/23. 9 or 10/11.
6th of June 2024.
ঠিক বলছো?
Just now he has handed us this copy just now saying that this.
This is the
ওটা আমাকে একটু দাও। আমাকে একটা কপি দাও।
my lord, in my application, my lord, page 85.
We are asking him, is it part of the record?
My lord, page 85.
So this is the bank entry.
Yes.
What is the date?
My lord, 6th June 2024. Left hand column, my lord.
So after the order passed by the tribunal
Yes.
in OA 109, did they challenge that order?
No.
No.
Then why do you take so long to comply with the tribunal's order?
I take just 10 seconds, my lord. My lord, incumbent died on 9th of November 1992.
Correct. He took voluntary retirement on 31/9/76.
Yes.
He died on 9/9/92. OA was allowed on 4/7/22.
Yes.
The payments made on 6/6/24.
Mine.
Why so after such a long time?
I cannot justify what has already been done. But now, before your lordship, they are on a different point.
No, we have understood. You are opposing it that they have not got it in the earlier round, so they cannot get it in this round.
Yes.
You have understood.
And the copy which your lordship supplied us, my lord, kindly have a look into paragraph 4 of that notification.
No, we have seen that issue does not arise here.
Yes.
Not on, my lord, paragraph 4 does not speaks only about gratuity, but the interest for gratuity as well as area pension.
Mr. Dalpati, just see the nature of order passed in 109. If this order had not been passed, even on that day, you would not have got the pension. You were not able to comply with the requirement. The court found a way out that treat this as the substantial compliance. Then only you have got it. Where is the question of delay by anyone? Neither you nor them. In fact, if at all it is, why have you not come up for this benefit earlier? From 92 to 22.
For my
9/9/92.
my lord, so far
30 years.
is concerned, my lord, after demise of the original incumbent, they have made application for family pension and other benefits.
But they were not sure whether you were the beneficiary or not, and you are not able to justify that you are the beneficiary. So the tribunal found a way out that there is some certificate, treat this as a valid marriage certificate.
Lord, the government asked me
Legal heir certificate has been issued by the BDO and SDO. and that has been taken.
In our, at least in our state, my lord, the tribal family at that point of time have no marriage certificate. Even my lord, I can confess myself, my lord, even there is no marriage certificate of my parents.
That's not the point.
Right.
But then in respect of many people, even if there is no certificate, there is a nomination made in the service records. So for such people, they don't insist on certificates or any kind of proof that they are the correct and legal beneficiaries, because the service rules provide for nomination to be made in the record service book. So in absence of anything, it could not have been done.
My honest, humble submission before your lordship is, my lord, the government, the state take initiative since 2019. Although the application was made in 1992. Lord, all the documents which is required to release the pensionary benefit, that had been asked since 2019. And the state was...
That's why we asked, did you challenge this order? You did not challenge. Yes, take down. Our learned There has to be a finality to some court proceedings. It can't be left open like this.
Look, it is the
We are not saying anything on that. We don't know.
Twice they have approached the tribunal.
Even in the second round, you have not raised. How it can be? Cannot go on forever.
The state as well as my client also failed to say whether the gratuity amount
He
has.
may be right. At the time of voluntary retirement, he must have got it.
Yes.
He must have got it.
Otherwise, they would have raised this point in the first round.
PPO, it is not revealed, my lord. In the PPO, my lord, they annexed.
That is not the subject. That is not the subject matter of the present proceeding.
Not even the two ways.
Yes. That's enough. Yes.
Great.
Much obliged.
Item number 89.
For the state appellate is engaged in courtroom number 16.
Not today. Oh, you are appearing. Will you be here tomorrow? Not today.
Mm-hmm.
90.
90, Your Lordship. Appearing on behalf of the petitioner, I am led by my senior advocate, Mr. Sumit Sanyal. We received the affidavit in opposition yesterday at 1:05 p.m. Lordship, I am praying for 2 weeks.
Should the affidavit?
The
Affidavit in opposition.
Item number 91.
No, this is my appeal. On the last occasion, I argued that non-filing of the Bhokalatnama by the advocate on record, who has already been filed a Bhokalatnama before the writ court, the appeal is the continuation proceeding, and on that ground, there is no requirement to file a fresh Bhokalatnama in the appeal court. But on that day, Lordship directed me where is the provision. Before avoiding the future complication, I already been filed Bhokalatnama. But for my academic discussion in my own satisfaction, the order 3 rule 4 sub rule C, there is the provision that is the deemed to be a continuation of the proceeding. Order 3, if your Lordship.
CPC. CPC. CPC is right there.
For appointment of pleader. আচ্ছা সাহেবকে দিয়েছেন? Appointment of pleader. Explanation. For the purpose of this sub rule, the following shall be deemed to be a proceeding in the suit. C. An appeal from any degree or order in the suit.
This arises out of a suit.
This is not a suit, but all principle of the code of civil procedure be applicable in the appeal court.
Yes. All right.
Lordship, that this appeal paper after 75 days from the statutory period of the section 5 application has been filed.
Yes.
And a 75 days delay for the purpose of this filing of this appeal. I already been served a copy of the application as well as this is my affidavit of service. And আবার একটা দিতে হবে, একটা তো হবে না।
The order of the writ court is dated 21/8.
Only grievance of the petitioner is that in the four-wheeler, there is not a provision for AC and audio facility. In spite of that, the Vahan portal, there is the indication that in the said car, there is the enjoyment the AC and audio facility. But that facility is not available in my car. In spite of that, the authority RTO impose huge taxes against me, and against that the deed application has been filed. But at this stage, I am only praying before your lordship.
Yes.
Before your lordship, only appointment any receiver or advocate commissioner or departmental man for inspect the said card. That there is any provision for audio facility and AC facility or not. If my car has not been enjoying the audio facility and AC facility,
Today, whether it has or not, that is not relevant. Today, it may not be having, we don't know.
If there is no provision for installation of those facility, therefore question of previously or earlier and present does not arise.
So what is the infirmity in the order passed by the Honorable Single Judge?
The only on the order passed on the only basis of the Bahun portal, where is the indicated that this car is enjoying the AC facility and audio facility. But the practical purpose is that there is no audio facility and AC facility.
What is the procedure under the Motor Vehicles Act or rules? How it is to be determined? Which procedure lays down that before imposition of tax, there has to be an inspection to see whether these facilities are there or not? Where is that provision? Let us see. You are in a writ court. The procedural aspect, the decision-making process, not the decision. So where is it? Your certificate of registration says AC yes, audio yes, video no. So what remains? Come to page 17 of the writ petition.
This is correct. I am not on that ground, but
We are on that.
But
where is the scope for anyone to examine anything?
Otherwise, I am not enjoying the AC facility.
You may keep it off. We don't know.
Where I will go? The authority did not.
Which is the application for condonation?
Not condonation is the grounds is that initially I obtained the certificate.
We are asking you what is the infirmity in the single judge's order. We are not asking you whether you enjoy the AC or not. This is not a fact-finding court that will examine whether you are enjoying it is there or not. There is a registration done by you where you say it has AC and you say it has audio. Now you say I'm not enjoying. And on that basis, you should be exempted from the tax. Earlier, you have been paying tax considering it as having AC and audio. So, that's why we said, what is the infirmity in the order? Tell us.
Now you'll also
Otherwise, why we should interfere in the order? Who is for the state? Who have you served?
Let us already certified. Not very well. I will come back over after notice to the state advocate, if your lordship. That's it.
Difference between tax, non-AC and
Notice to be served, notice to be served on the reflect the date of next year. 9/2025.
My lord, before my learned friends start, my lord, at the very outset, my lord, my humble submissions before the lordship. Till today, my lord, I don't have the copy of the writ petition. Well, this is the third time, my lord. I prayed, lordship, I mailed him, lordship. Till today, my lord, I have been handicapped with the copy of the writ petition, my lord. And my lord, there is a direction passed by your lordship to pass a supplementary affidavit filed by my lord. I don't know, my lord, whether my learned friend already filed the supplementary affidavit or not, my lord.
I'm 92. But I'm being led by Mr. Chaube in this case. I'm filing my affidavit of service, my lord. The matter has been served upon the petitioner, my lord, here, not the council, my lord, because this matter came from AFT. We are against an order of the appeal in the AFT order, my lord. So it has been served upon the petitioner here, my lord. I'm filing my affidavit of service. And my lord, yes.
I suppose to you are the petitioner.
Petitioner in the original application, my lord, before the AFT.
Well, my kind lordship till today not received the copy of this writ petition, my lord.
He is saying he has served on the applicant.
My lord, my instruction is, my lord, my client
However, my lord,
does not receive the copy, my lord.
an issue, my lord.
Yes, it is an issue because I am suffering.
You are suffering. I have served. I'm saying I can serve an additional copy upon my friend. The fact remains that I've served upon a copy of the petition to the original applicant, my lord. There was a direction dated 17/7/2025, whereby my lord said, my friend, senior friend, my lord, has raised an objection before the AFT for a correction against the order dated, my lord. And my lord has given a direction to file a supplementary affidavit after the order, original order against which we have come into appeal is corrected, my lord.
When was the notice served on the writ petitioner, applicant respondent?
My lord, I am not having, my lord, the date is there, my lord. I'm sorry, my lord. I'm sorry, my lord. I don't have a copy, my lord. Apologies, my lord. I could not Xerox it, my lord. My lord, this is not complete because there is a problem with the postal these days, my lord. I cannot get an update whether he received or not, my lord. So it is prepared as on, my lord. It was served on 16/6/2025, my lord.
16/6.
Yes, my lord.
Where do you say?
Find it from the Xerox of the consignment number, my lord, here. My lord, we couldn't get an update because these days, my lord, there's a problem with the software of the postal department, my lord. This is known to all of.
Presumption you are saying that you have served.
My lord, 16/6, my lord. That's why I said, my lord, that I will serve a
16/6
additional.
is service.
No, my lord, we have sent it through speed post on 16/6.
You are emphatically saying that already we have given to the writ petitioner.
No, my lord, I'm saying we have sent it to the writ petition, my lord.
So that is issuance is service.
My lord, by now we presume that it might have reached. That's why I said, my lord, this is my affidavit of service as on date when I took the printout, my lord. This is the update. So, my lord, that is the reason I humbly submit. I said that I will serve an additional copy upon my.
No, that's not the reason why you said. You said I have already done it. Still, I will do.
Yes.
You should have said you
I've
don't
sent
know
it.
whether it has reached. I will do it.
I stand corrected, my lord. We have sent it, but I cannot.
Why do you make a wrong submission?
My lord, I apologize.
Actually, wrong submission.
My lord, I apologize. My lord. I sent it, but I cannot.
You have not served.
My lord, I have sent, but I cannot accurately say whether it has.
Of survey does not say that it has been served. Take down.
As on 18, my lord, it was not. It did not.
There is no
3rd September. Hmm. 26 is today. Within Friday. 20. Next Friday. Grateful, Malad.
When is duty? Right.
तीन 93.
Order dated 10 July 2025.
No representation. Today again, there is no representation on behalf